The Senate will come to order. Members, before we left for our brief recess, I had not started to read through or go through the Senate agenda. That is where we will pick up at this time. Members, we will begin with the third order of business. Messages from the House. The Secretary will read the first message.
Mr. President, I have the honor to announce the passage by the House of the following Senate file as amended by the House, in which amendments the concurrence of the Senate is respectfully requested. Senate File Number 4579, a bill for an act relating to energy. Senate File Number 4579 is herewith returned to the Senate. Signed, Patrick D. Murphy, Chief Clerk, House of Representatives.
Senator Dibble for a motion.
Thank you, Mr. President. Mr. President, I move that the Senate do not concur in the amendments by the House to Senate File Number 4579 and that a conference committee of 3 members be appointed by the Subcommittee on Conference Committees on the part of the Senate to act with a like conference committee appointed on the part of the House.
Thank you, Senator Dibble. Senator Dibble moves that the Senate do not concur in the amendments by the House to Senate File Number 4579 and that a conference committee of 3 members be appointed by the Subcommittee on Conference Committees on the part of the Senate to act with a like conference committee appointed on the part of the House. To that motion, all in favor say aye. Aye. All those opposed say no. The motion prevails. Members, the Secretary will read the next message.
Mr. President, I have the honor to announce the passage by the House of the following House files herewith transmitted. House File Numbers 2895, 3204, and 3304. Signed, Patrick D. Murphy, Chief Clerk, House of Representatives.
Members, no action is required on that action. We will now proceed to the fourth order of business, first reading of House bills. The House files have been given their first reading and referred as indicated. Senator Murphy for a motion.
Thank you, Mr. President. I move to lay House File 3204 on the table.
To that motion, all in favor say aye. All those opposed say no. The motion prevails. Members, we will now proceed to the fifth order of business, which is reports of committees. There's a report to read at the desk. The Secretary will read the report.
Senator Marty from the Committee on Finance, to which was re-referred Senate File Number 5335, a bill for an act relating to human services. The Human Services Omnibus Budget Bill reports the same back with a recommendation that the bill be amended as follows. And when so amended, the bill do pass.
Senator Rarick.
Well, thank you, Mr. President. Mr. President, there's a provision in Senate File 5252 that was not heard in any committee, thus it did not make committee deadlines. So pursuant to Rule 21, I object to the reference on Senate File 5252.
Thank you, Senator Rarick. If you give me just one moment so I can get to Rule 21. And members, according to the rules, this bill must be referred without debate to the Committee on Rules and Administration to report the proper reference. Seeing that, that will be the action. All right, Senator Murphy for the motion to adopt the committee reports.
Thank you, Mr. President. I move the committee reports printed in the agenda and read by the Secretary be adopted with the exception of the report relating to Joint Rule 2.03, and I request a roll call.
Roll call requested, roll call granted. Any other discussion on that motion? Senator Pratt.
Thank you, Mr. President. I'd like to impose a call of the Senate, please.
The Senate is now under call. Senator Pratt.
Thank you, Mr. President. I move further proceedings under the roll call be dispensed with and the Sergeant-at-Arms be instructed to bring in the absent members.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. Members, we're on the adoption of the committee reports. Any other discussion? Seeing none, the Secretary will take the roll on the motion to adopt committee reports. Senator Umu verbatim for those voting pursuant to Rule 40.7.
Mr. President, Senator Dietzick votes aye,
Senator Dietzick votes aye.
and Senator Port votes aye.
Senator Port votes aye. Senator Jasinski for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Anderson votes no.
Senator Anderson votes no. All senators having voted who desire to vote, the Secretary will close the roll. There being 34 ayes and 33 noes, the motion to adopt is adopted. Members, we will now proceed to the sixth order of business, second reading of Senate bills. The Secretary will read the Senate file numbers.
Senate file numbers 5337 and 5335.
The Senate files have been given their second reading. Members, we will now proceed to the seventh order of business, second reading of House bills. The Secretary will read the House file numbers.
House file number 4661.
The House file has been given its second reading. Members, we will now proceed to the eighth order of business, which is the introduction and first reading of Senate bills. The bills listed on today's introduction calendar are given their first reading and as indicated, and referred as indicated. Members, we'll now go to the ninth order of business, which is motions and resolutions. I'll go to Senator Dibble, and then I will go to Senator Nelson and Senator Jasinski. I will do the author's motions first. We will adopt the author's motions as one motion. All in favor say aye. All those opposed say no. The motion prevails. Now, Senator Dibble, for your motion.
Thank you, Mr. President. I move that House File number 3800 be taken from the table, given a second reading, and placed on general orders.
Any discussion to that motion? The motion before the body is that he moves that House File number 3800 be taken from the table and given its second reading and placed on general orders. On that motion, all in favor say aye. All those opposed say no. The motion prevails. House File 3800 will be given its second reading.
House file number 3800.
Second reading. Now we will go to Senator Nelson.
Thank you, Mr. President. Mr. President, our Senate, we are in a very serious position. It is a known fact that one of our members is under indictment for a serious felony. Mr. President, we are a divided chamber, 34, 33, and it is essential that Minnesotans know, under the gravity of the situation before us, that we, this Senate, will stand accordingly and make sure that Minnesotans know that their representatives, their senators, are indeed capable and have the judgment to make the very serious, consequential decisions before this body. Mr. President, my motion, I move that any member of the Senate who during this 93rd legislature has been charged with a crime of violence listed in Minnesota Statute 624.712, Subdivision 5, be prohibited from voting on all matters before the body until the Subcommittee on Ethics has completed the investigation into the member's conduct and has submitted its findings pursuant to Senate Rule 55-8. Mr. President, I ask for a roll call.
Roll call requested, roll call granted. Senator Latz. I'm sorry, Senator Klein.
Thank you, Mr. President. Pursuant to Rule 27.1 of our temporary rules of the Senate, I request that the motion be placed in writing.
Senator Klein, I didn't hear the last of what you said because your voice tapered off.
Mr. President, pursuant to Rule 27.1, I request that the motion be placed in writing for the chamber.
Under that rule, a member can ask for it to be put in writing. With that being said, Senator Nelson, we would ask that be placed in writing. Senator Pratt.
Thank you, Mr. President. I request a call of the Senate.
The Senate is now under call. Senator Pratt.
Thank you, Mr. President. I move further proceedings under the roll call be dispensed with and the Sergeant at Arms be instructed to bring in the absent members.
On that motion, all in favor say aye. Aye. All those opposed say no. The motion prevails. Any other discussion? I think I had a list here. Senator Aaron May Quaid.
Thank you, Mr. President. And I'm just new to the Senate, Mr. President, and I think I'm still getting my bearings with both our rules and with Masons. I heard Senator Klein ask for a written, can you explain what that is, please?
Thank you, Senator Aaron McQuaid. We will pause and let me ask Senator Nelson a couple questions that have just been brought to my attention because pursuant to Rule 27, a motion or amendment must be in writing. If a member requested, it must identify the member or committee offering it. And when that motion is made, then I'm to get that in writing. So Senator Nelson, how long do you anticipate it taking in order to get that motion in writing? And I will pause all discussion until we have that in writing. Senator Nelson.
Mr. President, it should be at your desk momentarily. It's a very short motion.
All right, we will pause and wait for that motion in writing. Thank you, Senator Nelson. We will wait. Members, pursuant to Rule 27.2, when a motion is made, it must be stated by the President, which I've done. If it is in writing, it must be handed to the Secretary and read to the members. We do not have it for the rest as of yet, is my understanding, but I'm going to let the Secretary read the motion.
Senator Nelson moves that any member of the Senate who during the 93rd legislature has been charged with a crime of violence listed in Minnesota statutes section 624.712 subdivision 5 be prohibited from voting on all matters before the body until the subcommittee on ethics has completed its investigation into the members' conduct and submitted its findings pursuant to Senate Rule 55.8.
Members, do you have it in writing? All right, they are making copies and then they will be distributed. Then we will pick up the argument at that particular time. Senator Nelson, unless it's to your motion and you want to withdraw it, I have to wait and pause before any argument can happen as a result of your motion. Senator Nelson.
Mr. President, I will not be withdrawing. I did want to further elaborate on the motion, but I can wait until the appropriate time.
Thank you, Senator Nelson. You can wait because I believe that you did some elaboration before you gave the motion. So now we will pause in order to make sure that all the members have it and you will have an opportunity. And Senator Nelson, just to be clear, at the time the floor was being held by Senator May Quaid, but what I'm going to do is let you go so that you have another opportunity because you've been given the opportunity, and then I will call out the others from there. But let's wait until it gets to each member. So thank you for your patience. If I'm correct, I believe every member should have a copy in writing of the motion or the Nelson motion. Senator Nelson, to your motion.
Well, thank you, Mr. President. Members, you have the motion in front of you. As noted, it is a troubling time for our body, and we know that we're not perfect people, but the charge facing a member of this body is so serious and completely unprecedented. I believe it's important that we take this very serious step today. We should not be passing legislation in this body by one vote. We do have a process to review ethics complaints. And we must not defer action until after this body has already passed legislation of great consequences to Minnesotans by a single vote. The actions the Ethics Committee could take now over a member with such a serious charge are highly consequential. If we were to pass legislation with the full participation of a member charged like this, and only with that member's support would it be in place, would it be in law, would put all of our work under a cloud. We should uphold the integrity of the body and ensure that we are not passing critical legislation with the deciding vote being under such scrutiny. I encourage a yes vote. That scrutiny should not be under this dome with what we are doing as a body. That person needs to not vote now on these very important issues until the Ethics Committee reaches its conclusion.
Senator Ronletz.
Mr. President, will Senator Nelson yield for a question?
Senator Nelson, will you yield? She will yield. Senator Latz.
Thank you, Mr. President. Senator Nelson, could you please cite the constitutional, Masons, or Senate Rules authority for the action that you are seeking here, disqualifying a duly elected member of the Senate from voting?
Senator Nelson, to the question.
Thank you, Mr. President. Senator Latz, I do not have that constitutional authority to answer your question, but I can tell you that Minnesotans, to a T, have said under any other entity, any other circumstance, such a charge, whether it was to a teacher or a police officer, each one of those people would be put under administrative leave. It is not a limiting due process. It is not assigning guilt, just like administrative leave is not. It is important that our body make sure that the one vote in question, due to the unprecedented, not just charges, police report, 911 call, certainly what we do in this chamber must not be under the cloud of scrutiny that it was passed by one vote by a member who has not been dealt with in regard to this behavior that is so unbecoming, not only of a senator. It is disrespectful to the people that we represent. It is disrespectful to the body, and it is essential that that vote not be counted until there is some resolution.
Senator Latz.
Mr. President, will Senator Nelson continue to yield?
Senator Nelson, will you continue to yield? She will yield. Senator Latz.
Mr. President, Senator Nelson, you just indicated that the people of Minnesota have said that under other circumstances, other private employees or employees of a public body may be or should be placed on administrative leave. Can you cite an example which is comparable to a duly elected member of the elected legislature?
Senator Nelson, to the question.
Thank you, Mr. President. Senator Latz, it is a common employment standard throughout this state. All you have to do is look at the newspaper, and you will see that under circumstances like this, the members, the employees are placed under administrative leave. This is just a sense of saying this member should not be voting. It is perhaps an attenuated administrative leave.
Senator Latz.
Mr. President, so I guess the answer to both my first and second questions are no. There are no specific examples or citation to any authority whatsoever in our Constitution, Senate rules, or Masons that authorize the action that the motion before the body seeks to accomplish, which is to prevent a duly elected senator from casting a vote in this body. And there were no examples given of any comparable action, even in the private sector or in the public sector in the governmental agency, and as that in particular would be a decision up to the employer as to how they wish to handle that. There's no law mandating administrative leave either that I'm aware of. We do have the Minnesota Constitution, which of course is the highest authority governing what we do. And in Article 4 of the Constitution governing the legislative department, I can find no provision that authorizes the Senate, except in the ultimate process of expulsion, that authorizes the Senate to take any action that would disqualify a member of the Senate from voting. I'm looking through Article 4. They've got the terms of office of senators and representatives, how to handle vacancies. They've got restrictions on holding office, which applies, basically says you can't hold another office at the same time you're holding this office. Qualifications of legislators dealing with senators and representatives shall be qualified voters of the state, shall have resided in the state. Each house shall be the judge of election returns and eligibility of its own members in terms of the criteria set forth here in Section 6. Evidentiary rules. I don't see anything else in Section 4 or Article 4 of the Minnesota Constitution that addresses any of that. We obviously have adopted rules that set forth the process by which this legislature could consider disqualifying through expulsion a member of the Senate, but that, of course, would require a 2/3 vote, and we already have made that determination. It's going through the ethics process. We've already reached that conclusion last week. I'm looking through Mason's. Section 517 talks about action must be within the power or vote is ineffective, and no motion is in order that conflicts with the Constitution of a state, even if it were unanimous. Such a motion will be null and void. There's nothing that I can find in the Senate rules that authorizes the motion that Senator Nelson has brought before this body. And she's been unable to cite it. In fact, I would respectfully suggest that her own caucus leader, Senator Johnson, has reached a separate and different conclusion in response to a press inquiry last week. Senator Johnson is reported to have said, in response to the question, can she vote? Senator Johnson said she certainly can, either on the floor or with approval of the caucus leader, so she can vote remotely that way, or she can be here on the floor. So if there really isn't an issue, she should be here on the floor voting with us. So apparently Senator Johnson believes that she can vote. So query the basis for Senator Nelson's motion. At least there appears to be differing views within the minority caucus on this question. At this time, Mr. President, I'd like to raise a point of parliamentary objection under Section 517 of Mason's, that the motion of Senator Nelson is not in order.
And just for clarity, Senator Latz, can you repeat what you said towards the end, that you raised an objection pursuant to Mason's Section 517, and then I could not hear what you said after that?
That the motion is not in order. It's not properly before this body.
Members, if you give me one moment, I want to make sure that I turn to that Section 517 of Mason's, just so I can make sure. A point of order has been called around 517. Action must be within power or vote is ineffective. That's the section that Senator Latz has raised his point of order. Senator Latz, any other debate or discussion on your motion before I go to other members if they want to debate that question? That point of order, I'm sorry.
Mr. President, I would include all of Section 517 in my point of order.
Thank you, Senator Latz. Senator Jaskowski.
Thank you, Mr. President.
And members, just remember, I'm asking for advice. I was corrected just to make sure I say that so everybody knows that this is just advice. Advice to the President.
Okay, thank you, Mr. President. So, Mr. President, if we look at, to begin with, Mason's Chapter 1, Section 2 talks about the body's right to regulate procedure. And you'll see in there that we as a legislative body have an inherent right to regulate our procedure. It's very clearly laid out in that section in chapters in Section 2 and Chapter 1 of Mason's. But Senator Latz forgot a piece of Article 4, Section 7 of the Constitution. And apparently he may have missed a part here, Mr. President. I'm going to read Article 4, Section 7 of the Minnesota Constitution to the members. Section 7 says, rules of government. Each house may determine the rules of its proceedings, sit upon its own adjournment, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member. But no member shall be expelled a second time for the same offense. Mr. President, the Minnesota Constitution provides each house of the legislature, that's us, that's this body, Mr. President, has the authority to punish its members for disorderly behavior. That is exactly what Senator Nelson's motion attempts to do, and it is all of the authority that this body needs to do it. I encourage you members to vote against the point of order if indeed it's upheld by the President. But Mr. President, I'd encourage you to not support the point of order because it is not in order as outlined in the member's earlier motion. Thank you in Senator Latz's earlier motion. Thank you, Mr. President.
Any additional advice? Senator Pratt.
Thank you, Mr. President, and thank you, Senator Smiglewski, for talking about Masons and the Constitution. Mr. President, I'd also refer you to Senate Rule 56.1. Members shall adhere to the highest standard of ethical conduct as embodied in the Minnesota Constitution, state law, and these rules. Section 56.2. A member shall not publish or distribute written material if the member knows or has reason to know that the material includes any statement that is false or clearly is misleading. Section 56.3, improper conduct includes conduct that violates a rule or administrative policy of the Senate, that violates accepted norms of the Senate behavior, that betrays the public trust, and that tends to bring the Senate in dishonor and disrepute. Mr. President, with our rules and the citations that Senator Drazkowski mentioned, I believe that Senator Latz's motion is out of order.
Advice. Senator Nelson.
Thank you, Mr. President. I just want to respond to a couple of those arguments from the good senator from, well, let's see, where's Senator Latz from? St. Louis Park.
And Senator Nelson, I naturally assume that you're giving me advice. Is that correct?
I'm giving you advice.
Senator Nelson, advice.
Yes. I'm giving you advice for several reasons. Number one, the citation 517 does not fit for why this motion should be ruled out of order. And also, what I'm asking is reasonable. It is the expectation, and I want to remind members that the resolution itself, I want to make sure that you have the last phrase of that resolution because it will eliminate a lot of the objections that we heard. So members, let me draw your attention to the last sentence in the resolution. Until the Subcommittee on Ethics has completed its investigation into the members' conduct and submitted its findings pursuant to Senate Rule 55.8. That is all this resolution is, members. It is simply stating that until our Ethics Committee, as stated in Rule 55 in our Senate rules, has completed the investigation, this member accused of such a serious crime of violence should not be voting on the consequential, essential votes that are coming before this body in the next 3 weeks. It is common practice. In fact, let me give you an example of an elected official. The sheriff of Hennepin County also was unable to serve because of the seriousness of the crime of which he was committed. So the elected official was being put on administrative leave after an allegation of breaking the law. The Hennepin County Sheriff was forced to have administrative leave. This is what we must do. We are above the law, members. We should ensure that we are not above the law. No member is above the law, members. And we should ensure that our integrity of this body remains in place. It is essential that the Rules Committee do its job, start the investigation.
Members, just for clarity, because I heard it said a couple of times and I wanted to wait, what is before you is a motion. It is not a resolution. So that, and there's been a point of order that is pursuant to Section 517. I have a running list, so I'd like to go to Senator Johnson, who is next on that list. Senator Johnson.
Advice, Mr. President.
Advice, Senator Johnson.
All right. Just in addition to the citations that were given earlier in response to Senator Latz's question, there was another one that was missed here in Chapter 1 of Mason's Section 3, which also says state constitutions grant authority over procedure to each House and legislature by substantially the following language: each House shall determine the rules of its procedure. We do clearly have the opportunity to make those rules, and this would be one way of doing that. Thank you, Mr. President.
Senator Latz.
Mr. President, members, I'm going to take some of these point by point. Senator Drazkowski raised the issue of Article 4 and referred to the ability to punish disorderly behavior. I would respectfully submit that that phrase, as it appears in the Article 4 relating to the legislative department and the rules of government, that it relates to behavior in the conduct of the business of the state or the legislature, for example, on the floor of the Senate, not in one's private capacity. Secondly, with regard to the Rule 56 suggestion that this would have violated the rules under Rule 56. However, Rule 56 does not specify remedies, and a violation of the rule could be a basis for a decision by the body to expel a member if they felt that that was egregious enough, I suppose, for the Ethics Committee to make a determination that some other form of consequence is appropriate. But that doesn't give this body the authority under Rule 56 to enact the remedy of disenfranchising the people of the Senate district that elected a senator. Senator Nelson indicated that the last sentence in her motion is applicable here. I'm having some trouble following that logic because a violation or a remedy that would violate the Constitution, which is the basis for the Masons' point of order under Section 517, a remedy that would violate the Constitution violates the Constitution whether that remedy is temporary or permanent. So just saying for a few weeks we're going to disenfranchise all the voters of that district and not allow the duly elected senator to vote would be just as violative of the Constitution as if we were to do that on a permanent basis, short of the process authorized in the Constitution through expulsion. The example of the Hennepin County Sheriff is completely different. They're not covered by Article 4 of the Constitution relating to the legislature. And then with regard to Sections 2 and 3 of Masons, also identified, they deal with procedures. We have procedures that are set up consistent with our Constitution and under Masons. They're found in our Senate rules, which we all should have. Probably should have them at our desk if we don't. Those are the Senate rules. So if there wants to be a motion to change the Senate rules, go ahead, let's have that debate. But that's not the motion that's before us. And if we get to a motion to change the Senate rules, that also requires 2/3 majority to prevail. So members, all of the objections procedurally that you've heard on the floor here so far since I brought my point of order are not applicable to the point of order itself, and I encourage the President to rule accordingly and grant the point of order.
And just so that I'm being equitable, I have a list, and I'm going to go through that list. I put everyone's name down that have stood. Hold on one second. And as I call your name, if you no longer want to speak, just give me the sign, pass, okay? If you do, then it's your time up, and then I'll pause before we do a roll call. I'll pause and make sure the last voice that you'll hear will be the author, but I'll give everyone their chance and opportunity to speak on the point of order before we go any further, okay? With that being said, Senator McQuaid.
Thank you, Mr. President. I am looking at our rules, and I'm looking at 27.1, and it says a motion or amendment must be written if a member requests it. The second sentence says it must identify the member or committee offering it. The motion I have before me does not have that information on it, and I feel like we should have it in order and appropriately as stated by our rules before we proceed.
We have one motion that is before us, which is the point of order, so I have to take these in order if that's okay. If you want to come back to that, we can certainly do that, but I have to take one motion that's before the body at a time. Senator McQuaid.
Thank you, Mr. President. I appreciate that reminder. You know, Mr. President, I think the motion that is before the body, the point of order, excuse me, should be well taken. We are looking at a highly specific resolution here. And I think there's a reason why it is so specific to this moment, this time, in 3 weeks. We have heard Senator Latz go through numerous provisions of both Masons, our rules, and the Constitution before us. We have to hold ourselves to those documents. And it is really, really important that we, especially when we create rules that would disenfranchise 80,000 voters in Minnesota, who could continue to send members, any district in this state could continue to send members to this Senate that have done things that we don't yet know all the information about or haven't been through an ethics committee process. It's why we have processes in the first place, Mr. President. And so I think the motion is well taken, or the point of order should be well taken, because we have laid out processes in many, many documents for how we proceed in challenging times. We're not the first legislative body that has proceeded through troubling times. And our processes, adhering to those processes, is how we get through those times. And it is how we best put ourselves forward so that no matter who is in power and how they're in power, we follow the standards that we have. And so you have had good points made to you, and I think they should be well taken in Senator Latz's point of order.
Members, this is still advice, and I'm going in order. Remember, this is not a resolution. This is a point of order that is before us. And even Senator Nelson's proposal is in the form of a motion and not a resolution. So with that being said, Senator Marty, he's passing. Senator Pappas.
Thank you, Mr. President. I also was looking at Mason's Section 4, Rule 2, which is the principal sources for our rules. And the first one is our constitutional provisions and judicial decisions thereon. So that's the presiding rule according to Masons. It says when there's a conflict between rules, these sources listed above are in this order. So first, there's the constitutional provisions where you cannot deprive someone of their right to vote in this body. Only under very limited circumstances. And then second would be adopted rules that we've been referring to, and third would be custom, usage, and precedents. So I would support the Latz motion that the Nelson motion is out of order and urge the body to support that.
Senator Dibble, are you passing? Senator Dibble.
Thank you, Mr. President. Mr. President, I would encourage you to find the point of order well taken. I think for all the reasons that have been stated earlier, Mr. President, we have established processes, we have due process, we have the Constitution so ably cited by Senator Latz. Mr. President, we have a fundamental value at stake, and that is that the people of every single Senate district are entitled to be represented. We have precedent, numerous instances where people have had allegations made against them, and they've been able to proceed and pursue the processes that are laid out both in the law, in our Constitution, in precedent, in our rules, established procedure and protocol, and have not questioned their ability to participate in their duly elected role, Mr. President. So, Mr. President, I think consideration of this motion is not in order, and we should just simply get on with doing the work of the people of Minnesota. The voters of a particular Senate district will have the opportunity to respond in due time. Our judiciary system, our rules process is underway. Measures have already been taken, Mr. President, and this motion is simply not in order. So, Mr. President, I would strongly encourage you to find in favor of the question of whether or not this is properly placed before us. Thank you, Mr. President.
Senator Drazkowski.
Thank you, Mr. President. Well, Mr. President, the advice from Senator Latz suggested that he had some understanding of the meaning of disorderly behavior in the Constitution in Article 4, Section 7. And I don't know from where he comes up with that meaning. He attempted to describe that it meant some sort of disorderly behavior that happens in the Senate chamber or when the person is serving in the Senate. There is nothing in the Constitution that limits the definition of disorderly behavior as outlined in Article 4, Section 7. There's nothing in there that says that Senator Latz's very narrow and limited description of what this should mean is what it means. There's nothing in there that says it means only this and nothing else. As a matter of fact, it should be clear to the President and clear to the body and instructive to the body. If we look at Article 4, Section 7 of the Constitution, Mr. President, in conjunction with our rules, Rules 56.3. Now, 56.3, Mr. President, is the rule that outlines and enacts Article 4, Section 7 of the Minnesota Constitution. It's our response as a body to how we deal with situations when we see violations of Article 4, Section 7 of the Minnesota Constitution. Again, that's in Rule 56.3 that reads, members, improper conduct includes conduct that violates a rule or administrative policy of the Senate, that violates accepted norms of Senate behavior, that betrays the public trust, or that tends to bring the Senate into dishonor or disrepute. And, Mr. President, the actions of Senator Mitchell in the last several days have done these. Her actions have brought the Senate into dishonor. Her actions have brought the Senate into disrepute. Her actions have brought a betrayal of the public trust. And, Mr. President, I've read so many articles on the violations that law enforcement has taken note of and charged and is standing very, very, very firm about. And I've got article after article, the U.S. Sun, the Star Tribune, the Detroit Lakes newspaper, Mr. President, NBC in Boston, NBC Los Angeles, the Chicago Tribune, NBC 10 Philadelphia, Fox 9 Cleveland, ABC 11, Raleigh, Durham, North Carolina, ABC 7 in Chicago,
Point of order.
the New York Post,
Point of order.
Flavis of Jamaica, Mr. President.
Hold on, Senator Jaskowski. For what purpose do you rise, Senator Klein?
Mr. President, I rise under Rule 36.2 of our temporary rules. The member shall speak only to the question under debate and shall avoid personality. We've had violations on two fronts on that regard. Personality was invoked, and the question before the body is whether the motion is in order, the LAT's point of order. We're not here to debate what is happening in the popular media around Minnesota.
Members, I don't want to have to rule on this, so Senator Jaskowski, that I'm going to ask you to only limit your discussions narrowly to the point of order that I'm seeking advice on. And if there's some other time, if there's an opportunity any other time, then that would be something that we would deal with at that time. So with that being said, I'm just gently asking you, limit your discussion to the point of order that is before the body pursuant to Section 517.
Thank you, Mr. President. Well, Mr. President, we have before us a motion from Senator Nelson. And Senator Nelson's motion attempts to fulfill the requirements in Article 4, Section 7 of the Minnesota Constitution. It attempts to fulfill the needs in Minnesota Senate Rule 56.3 that talks about betraying the public trust, bringing the Senate into dishonor or disrepute. And Mr. President, I am just showing you the extent of the dishonor and disrepute that this body is in right now. Senator Latz is suggesting that Senator Nelson's motion doesn't have any element of our rules of the Constitution or anything else to rely on. That's what I remember him saying, Mr. President, is that he's saying this is out of order because he's saying there's no foundation for it. There's foundation all over the place for this motion, Mr. President. Ask any person in Minnesota whether we should be talking about this right now or not. And 99.9% of them will say yes. Mr. President, this motion is perfectly in order. They're even talking about the disrepute in London, Mr. President. Thank you, Mr. President.
Members, I'm trying to go through the list and give you an opportunity, but I am ready to rule because it seems like our arguments are the same arguments. But I want to give you an opportunity if you have a different argument. I'll still go through the list because I don't want anyone to suggest that they were not given an opportunity to speak on this important issue. But I'm going to ask you gently to reframe your conversations or your discussion to the point of order that is in front of us that I'm seeking advice on. Now, with that being said, Senator Friends, did you still want to speak, or we can go to the next person?
No, Mr. President. I want to speak to the underlying Nelson motion. Thank you.
We're on the point of order, the last point of order. Senator Lucero.
Mr. President, the question before us is, will the Democrat majority allow for somebody accused of a crime of violence to continue to vote?
Senator,
the Senate rules say
Senator
that
Lucero,
the betrayal of the public trust.
Senator Lucero, just for a second, just for one moment, the issue before the body is the last motion, the last point of order. It is not whether the Democrats will allow anything outside of that. So please help me out, and let's make sure that we narrow our comments. And you can talk as long as you want if you want to, if you're talking about the point of order only, not anything else. With that consideration, thank you so very much. Senator Lucero.
Mr. President, Senate rules say that improper conduct includes conduct that betrays the public trust. Senator Mitchell's actions betray the public trust. The Democrat majority has already expelled her from committees. and has disenfranchised her actions on committees. The motion before us is to continue that. Somebody who is self-admitted having done something bad that violates the public trust from being permitted to vote on the floor. I urge you to rule the last motion out of order.
Senator Duckworth.
Thank you, Mr. President. I appreciate the opportunity to give you advice. And although we could certainly talk about a whole host of things, I do promise and commit to you that it will be advice. I think we've heard many people cite the rules here today that make it very clear that we as a body have the ability to hold one another accountable. The question is, do we have the moral compass to do so? And Mr. President, my advice for you isn't really grounded in any manual or book of whatever. My advice to you doesn't even come as a Republican to a Democrat, as a member of the Senate to another fellow member. My advice to you comes from one Minnesotan to another. And that is, as you weigh this consequential decision you're about to make, Mr. President, a kind of decision that you make fairly often in this body, but never as consequential as a decision you're about to make today, which will carry the weight of the integrity of this body, the Senate here in Minnesota, today and into the future. Take the math out of the equation, Mr. President, when you make this determination. Pretend that 33 or 34 does not exist, because that should not weigh into your decision-making process as you ask yourself and make the determination today whether or not we deserve to take a stand for the integrity of this body, for our state government, and on behalf of the people of Minnesota. Thank you.
Senator Pratt.
Thank you, Mr. President. Well, I know you mentioned that you were ready to rule, but I just wanted to give you one last piece of advice. So our Constitution, Article 4, Section 7, says we have the right, the obligation to manage our members. We talked about Senate Rule 56. Mr. President, I'd also point you to Section 561 of Masons. Section 1, a legislative body has the right to regulate the conduct of its members and may discipline a member as it deems appropriate, including reprimand, censure, or expulsion. That is including, that is not limiting. And then point 2, a state legislative body possesses inherent powers of self-protection. Mr. President, our Constitution, our Senate rules, and Masons all confirm that the point of order should not be well taken.
Next person on the list, Senator Housley.
Thank you, Mr. President. I urge you to rule this out of order. I just want to make clear what this vote does represent. A green vote will allow Senator Mitchell to vote just like everyone else. And members, are we really going to let a member who was accused of such an egregious crime be the deciding vote on these bills that will be passing through this body? Is the DFL majority going to let her vote? Mr. President, I hope you rule this out of order. A green vote, I request. Thank you.
Members, just so that we're clear, a roll call has been requested. A roll call was granted. It is the point of order that is, excuse me, I see roll call. Sorry. No roll call. I'm seeing that from the underlining motion. My apologies. Members, we're on the point of order from Senator Latz, pursuant to Section 517. I am now going to Senator Westland for advice.
Thank you, Mr. President. Advice, and I will be brief. I believe, Mr. President, that you should find the point of order well taken. What the good senator is proposing is an amendment of our rules on the fly. And under Rule 58, every proposition to amend a rule of the Senate must be referred to the Committee of Rules and Administration. And it must not be acted upon until the report of the committee is received by the Senate. What is the senator proposing to change? There's been reference to Rule 55.8 but a very critical part of that rule has been missed, Mr. President. It says, if after investigation the subcommittee finds the complaint substantiated by the evidence, it shall recommend appropriate disciplinary action. We have not had even a determination of probable cause, let alone an investigation and a recommendation. And has already been stated earlier, Minority Leader Johnson indicated that Senator Mitchell has a right to vote in this body. And lastly, Mr. President, I want to say this. I am a little concerned that there are members of the Ethics Committee sitting in this body right now hearing people make arguments on the merits of the complaint, and I find that to be equally inappropriate. Thank you.
Members, I'm still seeking advice. I'm running down to my last members. I'm going down to Senator Rasmussen. Advice. We're on the point of order, not the underlining motion.
Thank you, Mr. President. I do have advice. Given the seriousness and the gravity, Mr. President, of the decision that you're being asked to make on this ruling for this point of order, Mr. President, I would humbly request that you, under your prerogatives, submit this point of order to the Senate. I think just given the importance of this to the institution and to the proceedings through the end of session, I would just humbly request, Mr. President, that you utilize your prerogative to put this point of order to the body for decision. Thank you, Mr. President.
Senator Rasmussen, were you asking for a roll call? Oh, sorry about that. No motion, so no roll call. Sorry about that. All right, just so that we are keeping all these things straight, I wanted to make sure if someone was subliminally asking for something that we put it in the front of the body. And remember, we're talking about the point of order. That is what is before the body. With that being said, Senator Johnson.
Thank you, Mr. President. And I just want to reiterate the comments that were made earlier. This will be one of the most important decisions that you make as President of the Senate for this institution, keeping the integrity of this institution. By ruling this point not well taken, we can uphold that integrity of this institution and make sure that we can do our business for the state of Minnesota in a bipartisan way. And we are willing to do that. We are here to work. Senate Republicans are here to work on a bipartisan nature. So, Mr. President, I think by taking this as well not well taken, we can maintain the integrity of this institution going forward and do the business of Minnesotans. Thank you.
Members, we're on the point of order. Senator Latz, you will be last. You'll be the last voice that we hear. I am now going to Senator Westrom.
Mr. President, I'd like to start out my advice by asking a parliamentary inquiry.
Please state your inquiry.
Mr. President, can you remind the body and myself what is the specific point of order that Senator Latz has raised against the Nelson motion?
The point of order that has been raised by Senator Latz is that this action or the motion of Senator Nelson is inappropriate and should not be entertained because it's inappropriate. So pursuant to Section 517, that is what he's raising, that this action is not within the power or the vote that this body can take, and therefore it would be ineffective.
And Mr. President, parliamentary inquiry.
Please state your inquiry.
Mr. President, under Section 517 of what document are you referring to that the Senator Latz is basing his point of order on?
Thank you, Senator Westrom, for that question. Masons, Section 517.
And Mr. President, this is all part of my advice. I am going to help walk you through this, Mr. President, parliamentary inquiry.
Senator Westrom, I don't think I need you to walk me through it. I'm certainly able to analyze this myself. So
Mr. President, parliamentary inquiry.
Excuse me, I'm asking that you wait until I speak. You can certainly give me advice, but you don't have to walk me through it as if you need to do that. Senator Westrom.
Mr. President, parliamentary inquiry. Is Mason's higher precedent than Senate rules?
I'm just going to grab it for you just so that we're operating from the same place. So, Senator Westrom, if you look under Mason's, Section 4, where it gives you the sources of rule or procedure, the principal sources are as follows. Constitution, constitutional provisions and judicial decisions. Next is adopted rules. Those would be the adopted rules of this body. What we've heard has been Rule 55, which is the Subcommittee on Ethical Conduct. Third, or C, would be custom, usage, and precedent. And D would be statutory provisions. And then it would be E, adopted parliamentary authority. So your adopted rules is higher. Those rules are higher than Mason's.
Mr. President, thank you for that response to parliamentary inquiry. And Mr. President, my advice is you and me standing here simply set forth that the last point of order should not be well taken. For the integrity of the Senate, as you've just read to the body, Mason's is letter E, the fifth rung on the ladder, which is what the point of order has been raised for by Senator Latz. The top guiding principle and document is the state constitution. That's at the top of those 5 hierarchies. That has precedence. That is superior to any of the other documents, the rules, which are above Mason's. But the state constitution, Mr. President, is what resolves this question and point of order. So, Mr. President, to preserve the integrity of the Senate, to follow the Constitution, Article 4, Section 7, clearly sets forth the House shall set the rules and may punish its members for disorderly behavior. Senator Latz asked in his discussions before he made the point to the Constitution where we've got the authority to do that. Mr. President, others and myself are laying it out right in front of you. The Constitution is the highest precedent, the highest superior document we need to follow in the Senate, and it explicitly gives the Senate the authority and the guidance and direction to punish its members for disorderly behavior. That is what we have going on in front of us here. Mason's is the 5th level of precedence or priority in that hierarchy. And so, Mr. President, the Latz point of order advice is to find it not well taken and follow what the Constitution sets out very clearly. And, Mr. President, is a roll call an option before you have ruled on a point of order, if you would answer that parliamentary inquiry?
No, it would not be appropriate. What would happen depends on what my decision is. One can appeal that decision, and then a roll call can be requested, and then we will do a roll call vote as it pertains to the decision of the president.
Thank you, Mr. President.
All right, members. Did I hear? Senator Nelson, you're not being recognized at this point. You're on the list.
I'm on the list. That's all I need to know, Mr.
Okay,
President.
yeah, I thought we pointed to you and told you that you're on the list.
All right.
There you go. All right, Senator Klein. Any other members outside of Senator Nelson? Because once we go to Senator Nelson, then we're going to Senator Latz as the author of the point of order. All right, anyone else before Senator Nelson? Senator Nelson, it's you, and then it will be Senator Latz.
Oh, thank you, Mr. President. Let's just focus on the facts here, folks. Precedent has been broken. New information has arrived since we met last through the 911 report. This prohibiting of voting applies only until the Ethics Committee does its job. It has not at this point. It is essential, Mr. President, for the decency, the goodness of this body, our history, and our future, that the Latz motion be ruled out of order.
Senator Latz, your last voice, one we hear before I render my decision. Senator Latz.
Mr. President, none of what Senator Nelson just said went to the point of order, went to her underlying motion. What's before the body is the point of order. Whether Senator Nelson's motion is properly considered by this body is not about the underlying merits of that motion. This is an important decision. The decision is whether to uphold the Constitution of the state of Minnesota. And I respectfully submit, no persuasive authority within the Constitution has yet been provided that authorizes this body to disenfranchise a duly elected member of the Senate. I will suggest there is a provision in the Constitution beyond what I've already cited that addresses that point. Section 22, majority vote of all members to pass a law. No law shall be passed unless voted for by a majority of all the members elected to each house of the legislature. Doesn't say unless the legislature doesn't want them to. Members, that provision means that all members must vote on final passage. It's why you have a call of the Senate and you wait for members because they're required to vote. It's also why you announce members that are excused from voting. So the Senate doesn't have the authority to remove a vote from a member. The Constitution requires all members to vote. Section 561 of Masons, that was also cited, still provides a right to discipline, which is why we have Senate rules. And the Senate rules guide us in that regard. Again, it does not provide the authority to remove a duly elected member's right to vote. So in effect, the attempt to do so is an attack on all the voters of the Senate district that elected the senator and sent that person here to vote on their behalf. We have a process that we, under our rules, can go through to consider expulsion as is authorized by the Constitution. Until that process is complete and considered, we have no other authority to remove a senator's ability to vote. So before the President is simply that question of procedure. Is the Constitution violated or not? Masons 517 provides the procedural vehicle to raise that question. And that's what's before the President. I encourage you to find the point of order well taken.
Members, after listening to advice on the point of order from Senator Rasmussen, Senator Drazkowski, Senator Pratt, Senator Nelson, Senator Johnson, Senator Lucero, Senator Pratt again, Senator Duckworth, Senator Westrom, Senator McQuaid, Senator Pappas, and Senator Dibble, and Senator Latz, of course, as well. After listening to all the advice, the point of order is well taken.
Mr. President.
Senator Rasmussen.
Mr. President, I appeal the ruling of the President and request a roll call.
A roll call requested, roll call granted. The decision of the President has been appealed. Members, just for memory purposes, once we take the roll call, a green vote upholds the ruling of the President, and a red vote does not uphold the ruling of the President. Senator Westrom, for what purpose do you rise?
Mr. President, parliamentary inquiry. Is the Senate under call?
Yes. Any other question? Seeing no other questions, the secretary will take the roll. Members, please vote. Senator Umu verbatim. For those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Dietzick votes aye.
Senator Dietzick votes aye.
Senator Port votes aye.
Senator Port votes aye. All senators having voted who desires to vote.
Mr. President, remote voters.
Oh, sorry about that. Senator Jasinski.
Mr. President, waiting on one vote.
Senator Pratt, was that the reason why you rose? Okay. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Anderson votes no.
Senator Anderson votes no. Anyone else? All senators having voted who desires to vote, the secretary will close the roll. There being 34 ayes and 33 noes, the decision of the president is upheld. Any other discussion? Senator Drazkowski.
Thank you, Mr. President. I have a motion I'd like to bring as well, and I think it's going to be passed around, Mr. President.
Senator Drazkowski, I'm sorry that I didn't hear you. Please, again.
The printed version of my motion is forthcoming, Mr. President, but I will move it here if I can. I move that the Secretary of the Senate be prohibited from registering and recording the vote of any Senate member who, during this 93rd legislature, has been charged with a crime of violence as defined in Minnesota Statutes 624.712, subdivision 5, and that this be in place until the Subcommittee on Ethics has completed its investigation into the member's conduct and submitted its findings pursuant to Senate Rule 55.8.
Senator Frentz.
Mr. President, request a roll call. Did I understand Senator Drazkowski to say we are getting a written copy of the motion?
Roll call requested, roll call granted, and yes, he did say that a written copy is coming before the body.
Thank you, Mr. President. Once we have the written copy, I would like to speak to the motion.
Absolutely. We will pause for a moment in order to make sure that each member are in receipt of the written copy. Senator Pratt, for what purpose do you rise?
Thank you, Mr. President. I'd like to impose a call of the Senate.
The Senate is now under call. Senator Pratt.
Thank you, Mr. President. I move that further proceedings under the roll call be dispensed with and the Sergeant at Arms be instructed to bring in the absent members.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. We're still waiting for each member to receive a copy of the written Drazkowski motion. And once you receive it, I then will ask the secretary to report the motion. It appears that everyone has it. With that being said, the Secretary will report the Drazkowski motion.
Senator Drazkowski moves that the Secretary of the Senate be prohibited from registering and recording the vote of any Senate member who, during the 93rd legislature, has been charged with a crime of violence as defined in Minnesota Statutes Section 624.712, Subdivision 5, until the Subcommittee on Ethics has completed its investigation into the member's conduct and submitted its findings pursuant to Senate Rule 55.8.
Senator Drazkowski, to your motion.
Thank you, Mr. President and members. The motion, again, it should be in front of you, but this motion provides that a member that is charged or has been charged with a crime of violence, that the Secretary would be prohibited from registering and recording a vote of that member. And maybe it's helpful, Mr. President, for the members to know what is in 624.715, but subdivision 5 in that section outlines the crime of violence and the definition of what a crime of violence is. And I'll just read some of them for you so you can see kind of the category of crime that we're talking about here. And that includes felony convictions in areas including murder in the first degree, murder in the second degree, murder in the third degree, manslaughter in the first degree, manslaughter in the second degree, aiding suicide and aiding attempted suicide, assault in the first degree, assault in the second degree, assault in the third degree, assault in the fourth degree, assault in the fifth degree, domestic assault by strangulation, crimes committed for the benefit of a gang, use of drugs to injure or facilitate crime, simple robbery, aggravated robbery, carjacking, kidnapping, false imprisonment, solicitation, inducement, and promotion of prostitution, sex trafficking, criminal sexual conduct in the first degree, criminal sexual conduct in the second degree, criminal sexual conduct in the third degree, criminal sexual conduct in the fourth degree, malicious punishment of a child, neglect or endangerment of a child, commission of crime while wearing or possessing a bullet-resistant vest, involving theft of a firearm and theft involving the theft of a controlled substance, an explosive or an incendiary device, arson in the first degree, arson in the second degree, burglary in the first and second degrees, drive-by shooting, unlawfully owning, possessing, operating a machine gun or short-barreled shotgun, riot, terroristic threats, harassment, shooting at a public transit vehicle or facility, drugs, controlled substance in Chapter 152. And that's the list of offenses that, Mr. President, that would initiate or enact this motion upon approval by the body. I talked earlier during the debate around the point of order around Senator Nelson's motion about the disrepute, the dishonor, and the betrayal of the public trust that the offenses that we are seeing before us and all of the writing and information about them that have been propagated so widely throughout the world, Mr. President. It is our job as the carekeepers of this body, which belongs to the people of the state of Minnesota. It is our job, Mr. President, to ensure the integrity and continuing smooth, safe, and proper operation of the Minnesota Senate. And we are already seeing, Mr. President, because of this deep disrepute that this body has been placed in, we are seeing the dysfunction, we're seeing the disarray that this body is entering into. We're going to see problems with perfunctory things actually not happening, Mr. President. We're going to see those who want a bonding bill A bonding bill will not be happening if we continue to see what it appears to be the protection of this behavior at the expense of the integrity and the reputation of the Minnesota Senate. If we continue to see that, we're going to continue to see this dysfunction, Mr. President. We need to clear the slate. We need to bring back integrity and trust in the Minnesota Senate again. What I'm hearing from the people of Minnesota is you have an individual that has been charged with first-degree burglary as a member of the Minnesota Senate. The response from people is that person should not be voting. Over and over, just brought to me from people on the street without even me talking about the subject, Mr. President. They bring it up every time I talk to someone or see someone. We need to clear the slate. We need to bring honor and reputation and trust back to the Minnesota Senate. This motion will do that. Mr. President, members, I encourage your support, and I ask for a roll call vote. Thank you, Mr. President.
Roll call requested, roll call granted. Senator Weissenberg.
Thank you, Mr. President. I stand to support Senator Jarzowski's motion. You know, there has been lots of grandstanding here by the Democrats to let a person accused of a horrible crime to continue to vote, Mr. President. And that person has been victim blaming to make themselves the victim. Mr. President, 80,000 voters are not being disenfranchised by the Senate. I'll say that again. 80,000 voters are not being disenfranchised by the Senate. They have been disenfranchised by the actions of their senator.
Members, remember we are on the Jarzowski motion. Senator Frentz.
Well, thank you, Mr. President, and thank you, members. Members, the Jarzowski motion is basically, in practical effect, the same as the previous motion. I agree we should not have grandstanding. I agree we should not have dysfunction. What we should be doing is the business of the Minnesota Senate, which is what everyone's constituents sent them here to do. But since it's out there, Mr. President, we talk about due process in the Constitution. That means fairness. We talk about the presumption of innocence. That means to presume someone's innocent. And we talk about principles that are applied here in the Minnesota Senate. And in my district, Mr. President, we have a saying, if you don't live it, you don't believe it. Mr. President, would Senator Jarzowski yield for a question?
Senator Jarzowski, will you yield? He will yield. Senator Frentz.
Thank you, Mr. President. Thank you, Senator Jarzowski. Senator Jarzowski, were you present when Senator Johnson said of this situation when asked, can she vote? Senator Johnson said she certainly can, either on the floor or with the approval of the caucus leader. So she can vote remotely that way, or if she can be here on the floor. So there really isn't an issue she should have on the floor voting with us. Senator Jarzowski, were you here when that quote was spoken by Senator Johnson?
Senator Jarzowski, to the question.
Thank you, Mr. President. Thank you, Senator Frentz. Senator Frentz, I don't remember hearing that from Senator Johnson.
Senator Frentz.
Thank you, Senator Jarzowski. Thank you, Mr. President. I think the point is quite clear, members. Obviously, a member of this chamber who's elected by the people in their district comes here with the right to vote. That right to vote is apparently okay under some circumstances with the minority caucus, but only if we have an ability to influence where that vote goes. None of us are influenced by anything other than our good judgment, the council, and what the people in our district tell us. Members, vote no on the Jarzowski motion.
Members, we're on the Jarzowski motion. Senator Latz.
Mr. President, I rise to raise a point of order under Section 180 of Mason's.
State your point of order.
Mr. President, members, Section 180 of Mason's prohibits or gives the body the ability to prohibit dilatory motions. Any regular parliamentary motion, when improperly used for the purpose of delaying or obstructing business, is a dilatory motion under paragraph 1. And paragraph 2, every legislative body has the inherent right to protect itself from dilatory motions. Whenever satisfied that a member is using parliamentary tactics to obstruct business, The presiding officer should not recognize the member, but should rule that member out of order. Members, it seems like the intention of the motion, certainly the effect of the motion, will be identical to the one that we just disposed of from Senator Nelson. We have a lot of business left before this body today. We have at least 5 bills that are before us for special orders. All of the arguments that have been made in favor of this motion are identical to arguments that were made to Senator Nelson's motion, and is basically just obstructionism. And it's wasting this body's time to go through a separately, differently worded motion that's intended to accomplish the same effect, even if there were any authority for us to be able to change the duties of the Secretary, and even if that authority, if exercised, would actually invalidate a vote, which I contend it would not. The vote would still be cast and have effect, even if it were not otherwise acted upon by the Secretary. But independent of all of that, this motion certainly appears to be dilatory and not proper before the body under Section 180 of Masons, and I ask the President to rule this.
Senator Latz raises a point of order pursuant to Section 180 of Masons. Any advice before we go to the author of the motion? Senator Aaron McQuaid.
Thank you, Mr. President. Additionally, I would like to point you to Mason Section 695, the Journal Record of Proceedings. The journal is an official record of what the actions are of the body, and it should be clear, concise, and a record of what is done. And as such, I will encourage you to also find that this motion is dilatory and rule in favor of Latz's point of order, Senator Latz's point of order. Thank you.
Advice, Senator Lucero.
Thank you, Mr. President. I urge you to rule the Latz motion out of order. We are here. The Drazkowski motion that I have read is to uphold the public's trust. It is unfortunate that Senator Latz and the Democrat majority would consider upholding trust as obstruction. It is not an obstruction.
Point of order, Mr. President.
To uphold the public trust.
For what purpose do you rise, Senator Latz?
It appears that Senator Lucero is violating the President's own direction only to stand to give advice. He's just choosing a different point of order to do it under. I ask that the President ask Senator Lucero to stick to the advice.
Members, I don't want to, again, disrupt one's ability to argue, but it is a part of my responsibility to make sure that whatever argument is based on what is before the body. So I just ask gently if you would confine your comments to the motion, or excuse me, the point of order that is before the body, which is pursuant to Section 180 of Masons. Senator Lucero.
In giving advice, Mr. President, I listened to the author's arguments, and I'm countering the arguments that were given to you as advice to you, encouraging you to rule the Latz motion out of order, because countering the reality that the public's trust has been violated and the Drazkowski motion is in order because it seeks to uphold the public trust in this institution and not permit somebody accused of a grievous felony from having their vote recorded. Thank you, Mr. President.
Advice, before we go to the last person who will be Senator Drazkowski, I will go to Senator Westrom.
Mr. President, advice. Mr. President, in the point of order the Senator Latz raised, he used the word specifically dilatory motion. Mr. President, I would advise you that this motion is not a dilatory motion. It is a very serious issue the Senate needs to deal with. And it seems Senator Latz and the Democrats do not want to deal with this. Mr. President, I would urge you to find the point of order not well taken. This is not a dilatory motion, as Senator Latz used as his reasoning to rise to a point of order. This is a very serious matter. I wouldn't relegate it to dilatory.
Advice before we go to Senator Drazkowski, who will be the last person we hear before we hear final comments from Senator Latz if he has anything else to say, because it's his point of order. Senator Drazkowski.
Thank you, Mr. President. Well, Mr. President, so Senator Latz apparently doesn't like this motion, so he is finding some obscure piece in manuals in Mason's manual to bring up a point of order. Dilatory tactics, Mr. President, are tactics that are meaningless, time-wasting, minor, not important, detours. That's what dilatory means, Mr. President. It has absolutely no right to be in this discussion. There's nothing dilatory about pursuing and effectuating the Minnesota Constitution. That's what we're here doing today. That's what my motion does. You ask any Minnesotan whether pursuit of this part of the Constitution and the condition we're in here today is important or not? And Senator Latz says it's not important? Mr. President, there's nothing dilatory about this. It couldn't be more substantive before us today. And we have members of this body actually entertaining that type of debate, Mr. President. That in itself is dilatory. Mr. President, I urge you to find the point of order not well taken. The motion I brought forward is purely and abundantly an effort to pursue and effectuate the provisions of the Constitution that this body is directed with doing under these circumstances. And unfortunately, members of the majority want to do otherwise. Thank you, Mr. President.
Last voice we'll hear before I render my decision will be that of Senator Latz.
Mr. President, well, the specifics of the motion before the body from Senator Drazkowski is to prohibit the Secretary from doing his assigned duties as the Secretary of the Senate. That's the motion that was brought. It has nothing to do with upholding anything else, any other public messaging, trying to say conduct was bad or anything like that. That's what the motion is that's before the body. The purpose of the motion is identical to the one that immediately preceded it, which makes it dilatory. And dilatory is defined in Mason's. When improperly used, any parliamentary motion improperly used for the purpose of delaying or obstructing business is a dilatory motion. By taking advantage of parliamentary tactics in this motion, they could practically stop business, which seems to be what is the attempt here. Certainly the effect here is to keep us busy debating these motions rather than doing the business that the people of Minnesota sent us here to do. This is not about the underlying merits of any alleged unethical conduct. It does not assume facts about what that conduct might be and whether there are any legal defenses to it. We're not here to do that here today. This is only about Senator Drazkowski's motion to have the same effect as the one that Senator Nelson's motion had, but the mechanism for that is to refuse to allow the Secretary to do the job that he is assigned to do. That seems to me as dilatory, and I encourage the President to so find and rule the motion out of order.
Having taken advice from Senator Westrom, Senator Lucero, Senator May Quaid, who took us to Section 695, to Senator Latz and to Senator Friends. Having taken in all that advice, I find that the last point of order well taken.
Mr. President.
Senator Jaskowski.
Mr. President.
Thank you, Mr. President. I move to appeal the chair's decision and ask for a roll call vote.
Roll call requested, roll call granted. Senator Westrom, is there any?
Mr. President, just confirming the House is under call.
Oh.
Senate's under call.
Thank you. The House is under, excuse me, the Senate is now under call. We're under call for the Senator, for the point of order. For the entire motion, let me put it that way. Members, remember, you're not voting as of yet. This is just for under call. We want you under call. Okay. So it's my understanding again that we're already under call, and we do not need to renew that. Now I'm directing us all for the secretary to take the roll on the appeal.
Mr. President.
Hold on a second. Senator Westrom.
Mr. President, appealing the ruling of the chair is debatable, as I understand. Is that not correct, Mr. President? Parliamentary inquiry.
It is debatable, but we seldom do it. Would you like to say something about the?
I would, Mr. President.
But now we're under. Hold on. Let me just make sure that we have some clarity here. If you want to take debate, we would close the roll and then wait until you have the opportunity to debate the appealing of the president's ruling. What would you like to do, Senator Westrom?
Mr. President, I would like to debate your ruling and why members should oppose your ruling and vote red on this motion.
I'm directing the secretary to close the roll, subject to asking you to reopen it later for us to deal with the appeal of the president. So let's do one step at a time. Senator Westrom, you are now limited to appealing the ruling of the president, and that only. Thank you, Senator Westrom, for your consideration.
Mr. President, I rise to oppose the ruling that you just rendered to the Senate body, calling the Jaskowski motion deleterious, as Senator Latz raised in his point of order. Members, I urge you to vote no and not uphold the president's ruling. The only thing deleterious that's going on right now is Democrats trying to use parliamentary procedures to avoid this issue. The Senate needs to talk about this. This is properly in front of us, and let's not use dilatory processes to try to duck the question at hand. Mr. President, I urge a no vote against your ruling and override the president's decision.
Thank you, members. Anyone else? Seeing none, the secretary will now take the roll. A green vote upholds the decision of the president. A red vote doesn't. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Anderson votes no.
Senator Anderson votes no. Senator Morrison, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Dietzig votes aye.
Senator Dietzig votes aye.
And Mr. President, Senator Port votes aye.
And Senator Port votes aye. Members, please vote. All senators having voted who desires to vote, the secretary will close the roll. There being 34 ayes and 33 noes, the decision of the president is upheld. Members, we are under motions and resolutions. I will now call on Senator Murphy to designate special orders.
Thank you, Mr. President. Pursuant to Rule 26, I designate the following bills be made special orders for immediate consideration. Members, the list is on your desk.
Members, as indicated, Senator Murphy is correct. The special orders list is on your desk, and we will start today with Senate File 3766 with none other than Senator Dahms. Senator Dahms.
Well, thank you, Mr. Chair and members. Today we have Senate File 3766. 3766 is a bill that dedicates a bridge over the Minnesota River on U.S. Highway 212 as the Mayor David Smiglewski Memorial Bridge. Mayor Smiglewski first joined the Granite Falls City Council in 1979 at the age of 26. He was appointed mayor in 1996. He held this position until his death on September 22, 2003 at age 70, following complications with ALS. Mayor Smiglewski showed exceptional leadership when his community suffered from traumatic floods and a tornado. David showed his dedication and love for Granite Falls by serving on the local food shelf, Project Turnabout, Kiwanis, Coalition of Greater Minnesota Cities, where he served on the board, Southwest Corridor Transportation Coalition, in the League of Minnesota Cities, and other organizations. Mayor Smiglewski was very passionate about the transportation issues. When he passed away, he was in Washington, D.C., lobbying for rural Minnesota transportation infrastructure. Designating this bridge in memory is fitting tribute to the mayor, Mr. David Smiglewski. Members, I would ask for a green vote in support of his memory.
Any other discussion on Senate File 3766? Seeing none, the Secretary will give the bill its third reading.
Senate File Number 3766, a bill for an act relating to transportation, designating the bridge on marked U.S. Highway 212 over the Minnesota River in the city of Granite Falls as Mayor Dave Smiglewski Memorial Bridge.
Third reading. Any other discussion on the bill before we go to final passage of the bill? Senator Murphy.
Thank you, Mr. President and members. I will proudly vote yes for this proposal today on the floor. If you've spent much time at all in the western part of the state of Minnesota, you will have met Mayor Smiglewski. He was a welcoming voice. He was the leader in a community that required transformational leadership at a time when we were tested. He was loved. He's spoken of often by his fellow mayors and people that live up and down the western spine of the state of Minnesota, and more broadly by those who have been able to get to know the people across the state of Minnesota. This is a very important piece of legislation, and I hope that we all vote yes.
Any other discussion before we go to final passage? Seeing none, the Secretary will take the roll on final passage of Senate File 3766. Members, please vote. Senator Morrison, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Dietzig votes aye.
Senator Dietzig votes aye.
Mr. President, Senator Port votes aye.
Senator Port votes aye. Senator Jasinski, when you're ready, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. I'm ready. Senator Anderson votes aye.
Senator Anderson votes aye. All senators having voted who desires to vote, the secretary will close the roll. There being 64 ayes and 0 noes, the bill is passed and its title agreed to. Senator Dahms for a motion.
Mr. President, I move for a brief recess to the call of the President.
On that motion, all in favor say aye.
Aye.
All those opposed say no. The motion prevails. Senator Dahms.
Well, thank you, Mr. President and members. Today in the gallery, we have Mayor Smiglewski's wife, Cindy, his children, grandchildren, and other family members, friends, and officials from the city of Granite Falls. I would ask my colleagues to join me in a warm welcome to the family members that have joined us today in passing this bill.
Members, please stand. Thank you, members. The Senate will come back to order. Members, we're still on the special orders list. We'll now go to House File 3868. Senator Kreun.
Thank you, Mr. President. On to what we've all been waiting for. House File 3868, which is revisions to the Uniform Commercial Code to accommodate emerging technologies. Mr. President, I'll go through here with some probably common questions that people might have about this subject. First and foremost, what is the Uniform Commercial Code? Mr. President, the UCC is a comprehensive set of laws governing all commercial transactions. The UCC is the premier uniform law that makes commercial transactions across the state lines easier when businesses understand they are using one set of rules across the country. The UCC has been adopted in all 50 states, plus the District of Columbia, with the exception of Louisiana, which has only adopted part of the UCC, which makes them an outlier. And Mr. President, when it comes to the UCC, you don't want to be an outlier. Mr. President, parties to a contract they may contract their own way, and when they do, that's what's going to govern. But when they don't, the UCC is the default set of rules that will apply, setting a level of certainty for Americans to conduct business from one state to the next. The next question you might have, Mr. President, is how long have we had the UCC? The first model UCC was adopted in 1952 and first adopted in Minnesota in 1965. The next question you might have is who actually comes up with changes to the UCC? The answer to that question is the Uniform Law Commission, in consultation with the American Law Institute and the American Bar Association. Those three groups periodically look at the UCC to make sure that it stays current and relevant for its purpose of making commercial transactions easier. The next question you might have, Mr. President, is when was the UCC last changed? The answer to that is 2012. So this is the first opportunity for most of us to vote on updates to the UCC, which is very exciting. And what this bill does is, a lot has changed since 2012 in terms of technologies, and that's really the central focus of this bill, to accommodate those new technologies. Mr. President, 19 states have already adopted these proposals, and I believe it's been introduced in 10 other states. Mr. President, the next question is, what are the proposed changes? There's several of them. I'm going to focus on just 5 of them. Mr. President, it creates a new Article 12 that aims to modernize and clarify existing commercial law for the transfer of property rights and digital assets, cryptocurrencies, non-fungible tokens, and other similar assets. The second thing it does is it modifies Article 9, and it creates the mechanism to create perfection and security interests in those digital assets. The new provisions in Article 9 will facilitate the use of digital assets as collateral for a loan, for example. The third thing it does is it creates new rules for what we call hybrid transactions that involve both the sale or lease of goods and the provision of other property or services. The fourth thing it does, it updates rules for electronic negotiable instruments. And the fifth thing that does is it updates terminology to allow for electronic signatures in documents. It does other things, Mr. President, concerning tethered assets, clarifying governing law issues and chattel paper. But the 5 I listed are what I think are the primary changes and highlights of this proposed bill. Finally, Mr. President, what this bill is not. This bill does not address federal or state regulation or taxation of digital assets or money transmitter or anti-money laundering laws. And then, Mr. President, on page 132, this bill specifically says nothing in this act supports, endorses, creates, or implements a national digital currency. Mr. President, I encourage a yes vote to update our UCC statute to ensure commercial transactions in Minnesota remain as efficient as possible, helping our economy be as strong as possible. And I'll stand for any questions. Thanks.
Any questions or discussion on House File number 3868? Seeing none, the Secretary will give House File 3868 its third reading.
House File number 3868, a bill for an act relating to commerce, adopting amendments to the Uniform Commercial Code to accommodate emerging technologies.
Third reading. Any other discussion on House File 3868 before its final passage or a vote on its final passage? Seeing none, the Secretary will take the roll for final passage of House File 3868. Senator Morrison, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Dietzig votes aye.
Senator Dietzig votes aye.
Mr. President, Senator Port votes aye.
Senator Port votes aye. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Anderson votes aye.
Senator Anderson votes aye. All senators having voted who desires to vote, the Secretary will close the roll. There have been 59 ayes and 4 noes. The bill is passed and its title agreed to. Members, we will now go to House File 3376. Senator Hoffman.
Thank you, Mr. President. I move that the amendment made to House File number 3376 by the Committee on Rules Administration in the report be adopted April 18, 2024, pursuant to Rule 45 be stricken. Thank you, Mr. President and members.
The Secretary will report, I'll just go to it. Senator Hoffman moves that amendments to House File 3376 by the Committee on Rules and Administration in the report adopted April 18, 2024, pursuant to Rule 45 be stricken. To that motion, Senator Hoffman.
Thank you, Mr. President and members. And with that, I just accept the, can you vote yes on this so we can move on to what's next on the bill? That's it.
On that motion, all in favor say aye. All those opposed say no. The motion is adopted. Senator Hoffman.
Mr. President, members, imagine this, right? What you have in front of you is the other body, which you can see on the board. It says HF, but the other body, number 3376. And the reason why we're picking it up from the other body is because there are 3 provisions that we needed to add to this. And let me explain what this bill's about. Imagine you're on your way to, I don't know, Laverne, Minnesota, because you're recording at, I don't know, Paisley Park, and you're driving down Highway 5, and somebody says to you, Mr. President, or maybe somebody who's another musician on their way to Laverne, Minnesota, and they say, wait a minute, the muskie are jumping really big in St. Anne's, or in Ann Lake there in Victoria. Or if you want to go all the way to Waconia, because, you know, you would have to stop in there. And lo and behold, you want to go fishing, but you didn't remember your little piece of paper that you, of course, went a couple days earlier and purchased from, you know, I don't know, one of your local convenience stores. And if you're in Laverne, Minnesota, that convenience store could have been, I don't know, the corner, you know, drugstore or something, right? Anyway, on your way there, Mr. Chair, in the past, you would have said, man, I can't stop at Lake Ann or Lake Waconia to go fishing because the muskie are jumping, but I got to do my recording of some song that maybe somebody did at some time in their life on my way to Laverne to go meet with some people. Because it was in law that you had to have a piece of paper that had your little fishing license. Well, what this bill does, members, it's really simple. It provides the clarity that makes the gap between getting your game fish license as proof of possession of the license, and it's on your little mini telephone. So with that, members, any questions on that? Please support Laverne, Minnesota, and the fact that you like going fishing for muskie. And by the way, you want this bill, because this makes sense, to have it digital versus having a piece of paper. So, Mr. Chair, please vote yes on this.
Any other discussion? Senator Liskey.
Thank you, Mr. President. Mr. President, will Senator Hoffman yield for a question?
Senator Hoffman, will you yield? He will yield. Senator Liskey.
Thank you, Mr. President. Mr. President, Senator Hoffman, I have one question and one question only. I have a lifetime fishing license in the state of Minnesota, and it says so on my driver's license. Would that qualify under this change?
Senator Hoffman.
Mr. President and members, you know, that's a great question to the good senator from Prior Lake, Minnesota, and actually from Morton down in that area, right? So I know the change that we're doing just adds the gap between the time that this becomes law in 2026 and now, but I don't see any reason why, to the good senator's point, that would be the same. So thank you, Mr. President.
Senator Liskey.
Thank you, Mr. President. Mr. President and Senator Hoffman, I'm from Lonsdale, Minnesota. I know it's a small town, tiny little town. We just crossed the threshold, though, of 5,000 people. So with that being said, I appreciate the answer and look forward to seeing this bill go forward. Thank you.
Senator Jasinski.
Thank you, Mr. President. I just want to recommend to Senator Hoffman that if he wants to go muskie fishing, he should muskie fish on French Lake in Rice County. Much better chances of catching a muskie. Thank you, Mr. President.
Any other discussion? Seeing none, the Secretary will give House File 3376 its third reading.
House File Number 3376, a bill for an act relating to natural resources allowing the use of a digital image as proof of possession of certain passes and licenses.
Third reading. Any other discussion? Seeing none, the Secretary will take the roll on final passage of House File 3376. Senator Morrison, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Dietzig votes aye.
Senator Dietzig votes aye.
And thank you, Mr. President. Senator Port votes aye.
And Senator Port votes aye. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Anderson votes aye.
Senator Anderson votes aye. All senators having voted who desires to vote, the Secretary will close the roll. There have been 64 ayes and 0 noes. The bill is passed and its title agreed to. Members, we will now go to House File Number 1989, Senator Klein.
Thank you, Mr. President. I will start with a motion. I move that the amendments made to House File 1989 by the Committee on Rules and Administration in the report adopted April 18, 2024, pursuant to Rule 45, be stricken.
Thank you, Senator Klein. On that motion, Senator Klein moves that the amendment made to House File Number 1989 by the Committee on Rules and Administration in the report adopted April 18, 2024, pursuant to Rule 45, be stricken. On that motion, all in favor say aye. All those opposed say no. The motion prevails. To the bill, Senator Klein.
Thank you, Mr. President and members. Thank you for entertaining the House File 1989, the Ticketing Fairness Act. I worked very closely on this bill with Representative Moeller from the House over the course of this session, and we met with almost every interested party who has a stake in ticket sales in the state of Minnesota, including consumer protection groups, the venues such as XL Energy Center and Hennepin Theater Trust, the teams, the professional sports teams in our area, the ticket sellers and resellers in our area. And we've come to a bill that is going to protect Minnesotans in very important ways and has the support of many of those advocates. This bill seeks to accomplish four things. First and most importantly is it enshrines the concept of all-in pricing for ticket sales. I think everybody has had the experience of buying a ticket to the Twins or to the Guthrie, and you think your ticket costs $65, and then when you get to the end of the sale process, all of a sudden it costs $89, and you're on a clock with 5 minutes ticking away, and it's not the economic investment you had anticipated. All-in pricing will require that all sellers give you the full price of the ticket at the onset of the sale process. It also precludes deceptive websites from purporting to be, for example, selling you a ticket directly from the Minnesota Vikings when they are in fact a ticket reseller. It eliminates the process of speculative sales, the process whereby ticket sellers or resellers may sell you a ticket that they are not actually in possession of yet on the anticipation that they'll be able to obtain some of those tickets through their bots later on in the process. It requires that sellers provide proof of purchase to the buyer within 24 hours, including their seat number. And it reinforces and affirms our federal prohibitions on bots and empowers the Commissioner of Commerce to request data from ticket sellers to see if they have observed bot activity in large volume ticket sales. Everyone has a story that sort of relates to being hit by junk fees when they try to buy a ticket, and I think this will, once passed, create some significant protections for Minnesotans, and I look forward to your support.
Further discussion of House File 1989. Senator Rasmussen.
Thank you, Madam President. One of the issues that has been brought up when we look at the ticket industry has been market consolidation. And actually, the Wall Street Journal recently reported that the Department of Justice is readying a lawsuit against Live Nation, which is the owner of Ticketmaster. One of the concerns that was highlighted in that article and that the Department of Justice is looking at is anti-competitive behavior in the marketplace, behavior that's designed to push out competition in a way that actually harms consumers, that harms the individuals who are looking to buy tickets on the marketplace. And one of the concerns, Madam President, that I have with this bill is that we are effectively giving Ticketmaster and Live Nation specific rights to block out competitors in the language of this bill. And I don't think that that's good for Minnesota consumers. I don't think that's good for a competitive marketplace, and it definitely isn't something that we should be doing in state statute. And I would direct members to page 4, line 11, in paragraph 5, where the language in this part of the bill, you could have two different ticket resellers who both own the tickets that they're looking to resell. However, by requiring the permission of the place of entertainment, many of which Live Nation has ownership stakes in, they could prohibit a competitor from advertising, offering for sale, or contracting for sale a ticket that they are in possession of. And so, Madam President, would the bill author yield for a question?
Senator Klein, will you yield?
I yield.
Thank you, Madam President, and thank you, Senator Klein. Senator Klein, could you explain the rationale for why we would want to allow one ticket reseller to be able to block another from selling the same product or advertising it as such?
Senator Rasmussen. Senator Klein again.
Thank you, Madam President. Senator Rasmussen, I appreciate your concern for the large and multivariate abilities of Ticketmaster and Live Nation, that they can operate both as a ticket seller and as a ticket reseller, and in rare cases, 2 cases in the state of Minnesota, as the owner of a venue. I appreciate that the federal government has launched an investigation and litigation to sort of pursue that, and I think that will require the continued vigilance of our Commerce Committee and this legislature to make sure that those relationships are not abused or used in a monopolistic fashion. In this bill, we were very careful to sort of address that with regards to the dual relationship of Ticketmaster as a ticket seller and a ticket reseller, and we precluded them from acting to self-contract with themselves to abuse that relationship. I think the area that you actually raised concerns about on Section 3 or Subdivision 3 at page 4 are the very essential pillar provisions of this bill that prevent speculative sales. That is, selling a ticket by any seller, StubHub, Ticketmaster, anyone, that they are not in material possession of. And that's a founding principle of this bill. It creates a significant risk for Minnesotans who attempt to buy tickets legitimately, and I stand by it.
Senator Rasmussen.
Thank you, Madam President, and I thank the bill author for speaking. I agree that we should have some consumer protections that make sure that we don't have resellers who don't actually have tickets trying to sell tickets that they don't have. However, that still leaves a concern here where under paragraph 5 on subdivision 3, if we had a reseller who actually has possession of the tickets, that a Live Nation-owned venue could block them from even advertising that they had those tickets. And so with that, Madam President, would like to offer the A3 amendment, and I'm happy to explain.
Secretary will report the amendment.
Senator Rasmussen moves to amend House File number 1989 as follows. Page 4, line 11, delete advertise. This is the A3 amendment.
Senator Rasmussen to the amendment.
Thank you, Madam Chair. Thank you, Madam President. The A3 amendment would still require that ticket resellers have possession of the ticket that they're looking to sell. However, it would remove anti-competitive language in this bill that could allow a Live Nation-owned venue to block a competitor from advertising and offering for sale a ticket that is within their possession, that they have paid for and that they are looking to resell. And so I think this is a common sense way to preserve many of the consumer protections that Senator Klein talked about and were the aims of his bill, while addressing potentially adding another anti-competitive barrier in an industry that is being actively investigated for anti-competitive behavior. I think the interests of bills that are coming out of the Commerce Committee and to protect consumers should protect consumers, not prevent competition and harm consumers who are looking to resell or to buy tickets and to attend sporting events, music venues, or the like here in Minnesota.
Senator Klein.
Thank you, Madam President, and thank you, Senator Rasmussen. Thank you also as always, for sharing the amendment with us in advance, so I had time to review it and think about it. I understand the purpose you're trying to prevent. I understand the threat posed by operators such as Ticketmaster that operates on many different levels of our economy and ticket sales. Nevertheless, I oppose the amendment. This strikes at the heart of a very essential provision within this bill, which is the prohibition of speculative sales. Members, I would ask you to vote no on the amendment, and I would request a roll call.
There will be a roll call. Further discussion of the A3 amendment. Seeing none, Senator Rasmussen.
Thank you, Madam President. And I want to just make sure we all understand what the A3 amendment does. It would still require the reseller to have actual or constructive possession of the ticket. And so we would still, if the A3 amendment is adopted, speculative ticket reselling would still be banned under this bill. What the amendment does is that it makes sure that the largest ticket player in the industry isn't able to explicitly have a right in Minnesota law to block competitors from being able to offer the same ticket for resale. If we do not adopt the A3 amendment, this language will actually ban them from even advertising that they have possession of the ticket that they would like to sell as a part of their business. I would urge members to vote in favor of the A3 amendment to address this anti-competitive provision that is in this bill so that we can focus on protecting Minnesota consumers and not the business interests of large corporations that are currently being investigated for anti-competitive behavior.
Secretary will take the roll on the A3 amendment. Senator Morrison, for those voting under Rule 40.7.
Thank you, Madam President. Senator Dietzig votes no.
Senator Dietzig votes no.
And Madam President, Senator Port votes no.
Senator Port votes no. Senator Jasinski.
Thank you, Madam President. Senator Anderson votes aye.
Senator Anderson votes aye. All members having voted, the Secretary will close the roll. There being 33 ayes and 34 noes, the motion does not prevail and the amendment is not adopted. Further discussion on House File 1989. Final comments, Senator Klein? Did you want to comment before third reading? Thank you. The Secretary will give the bill its third reading.
House File Number 1989, a bill for an act relating to consumer protection requiring disclosures relating to ticket sales.
Third reading. Senator Dibble.
Thank you, Madam President and members. I want to thank Senator Klein for House File 1989. I think that the provisions of this bill are going to go a very long way in addressing the issues that I'm sure every single one of us have heard from in our office in the aftermath of some of the more spectacular failures of the large ticketing systems to respond effectively to people's attempts to buy tickets to some of the more popular concerts that we've had here in the Twin Cities. But even when the concerts aren't nearly so popular, people run into all kinds of problems and deceptive practices that are extremely vexing. Just a few days ago, as a matter of fact, my husband went to go buy some tickets at a fairly small venue and immediately jumped onto a website that represented itself to be the venue. And we figured out pretty quickly that it was not, and in fact, we were being charged prices that were much, much higher than if we had gone directly to the box office of the venue itself. This drives people completely nutty, and it's really unfair, and it's very deceptive. And the other issue that Senator Klein addresses in his bill, of course, is the all-in pricing. I think that's going to go a long ways. We have that now, of course, when we buy airline tickets. It's a minimal expectation that we know as soon as we start the process of purchasing that ticket, before we get to the final screen, exactly how much that ticket's going to be. So we're not fooled by junk fees and invisible pricing and things like that. Madam President, the issues that Senator Rasmussen brought up are good issues. I think should be addressed. I think there's another way to get at some of those subjects, especially when we have a market that controls the ticketing, the promotions, the venues, et cetera. He's very much onto something. And so my request to Senator Klein is that we continue to work on these issues, ones that are raised by Senator Rasmussen, and then I have a few here too that are captured in a bill that I introduced, Senate File 4148. I'm glad that Senator Klein took the lead. I don't have to be the chief author of everything, but I hope we can continue to work on this because this is an excellent start. Some of the other things, of course, are the dynamic pricing. We saw the Springsteen concert. You know, I hopped onto that website early, and before I knew it, up the ticket prices went. You two had the same issue. Of course, the Taylor Swift concert we've heard a lot about. Senator Klein does require sellers to make clear when a ticket is being resold that it might be different from the original price, whether lower or higher. I think an important piece of information is to know what that original ticket price was. There are other issues just to clean up how this ticket market is gamed. Prohibiting the resale of tickets that are acquired free of charge would be an important step to take. Prohibiting the delivery fee for tickets that are printed. Why are we charged extra for just simply printing our tickets at home? Again, another junk fee that I think is worth examining and ultimately eliminating. Making sure there are stronger refund requirements for delayed events. And another way of manipulating the market, we really need to know when there's a number of holdback tickets. Whether that's the artist allotment, insiders, friends, VIP packages, special credit card customers, et cetera. It has the effect of creating a perceived scarcity and a artificial demand in the marketplace. So, Madam President, Senator Klein, thank you very much for this bill. I think it gets us 95% of the way there on addressing what's going on in this market. And there's a few more things that I hope we can work on in future years. Thank you, Madam President.
Further discussion of House File 1989. Senator Rasmussen.
Thank you, Madam President. And I would recommend a no vote on this bill. And I think it's very important that when we're looking at putting forward legislation with the aim of protecting consumers, that we do not entrench incumbent business interests and protect them from competition. And Madam President, I have concerns that without adopting the A3 amendment that was voted down earlier in this debate, that we will effectively be giving the largest ticket seller and reseller more power with our state statute. And I don't believe that we should be doing that with legislation, picking winners and losers, giving certain business interests exclusive rights to deny others from being able to compete in the marketplace. I think we could have today with this bill focused on prohibiting some of the most egregious behavior that we see in the marketplace, selling tickets that you don't have, having deceptive trade practices, and having junk fees that are attached on top of the advertised price for these tickets. We could have done that in this bill without picking winners and losers in a commercial marketplace. And so I would request that members vote against this bill, and this is something that we can continue to work on. The language of most of this bill is actually contained in a conference committee where we could debate and discuss this and fix these issues, but the bill before the body today doesn't address some of those issues that have been raised. Thank you, Madam President.
Further discussion before I recognize Senator Klein. Seeing none. Senator Klein.
Thank you, Madam President. Members, I want to congratulate the body on getting through this debate without a single Taylor Swift lyric being given. It was an accomplishment by all of us, I think, collectively. I would argue with Senator Rasmussen that this bill does a tremendous amount of good for Minnesotans. It will really make your ticket prices more transparent. It will give you protections around fraudulent websites, and I would encourage members not to let the perfect be the enemy of the good. Senator Rasmussen has some specific concerns about the behaviors of Ticketmaster and Live Nation, which I agree require vigilance, but which I do not feel are exploited by this bill. Members, please vote green. It's good for Minnesotans.
The Secretary will take the roll on Senate File, or I guess it's House File 1989, excuse me. Senator Morrison, on those voting under Rule 40.7.
Thank you, Madam President. Senator Dietzig votes aye.
Senator Dietzig votes aye.
And Senator Port votes aye.
And Senator Port votes aye. Senator Jasinski.
Thank you, Madam President. Senator Anderson votes no.
Senator Anderson votes no. All senators having voted who desire to vote, the Secretary will close the roll. There being 35 ayes and 29 nays, the bill is passed and its title agreed to. The next bill on special orders is number 74 on general orders, Senate File 5289. Senator Champion.
Thank you, Madam President. Thank you to the membership body. I hope to get your support today for Senate File 5289. It is a supplemental budget adjustments for DEED, or our jobs supplemental bill. Just so the members are correct, I'm not going to go through the whole thing line by line, but I'm going to make some particular comments about certain aspects of our bill. Senate File 5289 is the Jobs and Economic Development Supplemental Bill. It contains appropriations from the General Fund, as well as some appropriations from the Workforce Development Fund, as well as some recommendations from DEED, as I mentioned earlier. The bill reappropriates funds that have been reserved for costs related to the 2027 World Expo that's no longer needed after the city of Bloomington's bid to host the event was not selected. And we, of course, send our appreciation out to Bloomington for just being in the running to do something amazing when we think in terms of that expo. One of the other things that I hope that you will know is that we tried to address a couple of issues that were not initially a part of our Promise Act last year, for an example. One is Senator Pratt and others, along with Senator Pa and some of the others, suburbanites, talked about how the Promise Act was very thoughtful around rural Minnesota and greater Minnesota, Minneapolis, St. Paul, and as I mentioned, greater Minnesota as well. But the suburbs was not as highlighted as we would like for it to have been, because we wanted to make sure that we were doing something constructive for everyone. So in our bill, we made some modifications to the Promise Act where we allocated approximately $3 million for the suburban communities, because we want to make sure that the individuals, the small business owners, and others in those areas also have an opportunity to get some support. The second thing we did is that we added money for Uptown in Minneapolis. That's Senator Scott Dibble's bill, where Uptown was also experiencing some challenges during George Floyd, but also post-George Floyd. You also see that in Senate File 5289, we have a number of provisions to represent this body, whether you're talking about Democratic bills, but also some Republican bills. We are happy to have the Shakopee Chamber Foundation grants for the Area Workforce Development Scholarship Pilot Program. That's a Senator Pratt bill, as well as Senator Dornick. He had a request for grants for technical education programs offering instruction in meat cutting and butchery, and that is also included. So we are thankful for that. Senator Jasinski really did a wonderful job of talking about the city of Austin and grants for water operators and wastewater management training programs through Riverland Community College, and those are just some of the other provisions that are in this bill. Members, there's also a provision that Senator Hochschild really fought for, which is around adding the film board to the Office of Explore Minnesota. We thought that that was a better place for it. That was requested by a number of individuals, because we want Minnesota to be a destination place for folks who want to do film, and we want that to happen in real time. Members, we also wanted to make sure that this bill was responsible and thoughtful, so we also have in it all the reporting requirements that were suggested to us or continue to be suggested to us, and we continue to have it in our bill from Senator Draheim, and we wanted to make sure that that was done. Members, last but certainly not least, we had to make some modifications to our bill when it came to funding. So one provision in particular that we're going to continue, and even though there are others, but one provision in particular that we're going to do some work around is with Special Olympics. They had to ask for $4 million. We initially did the full ask, but then we had to make some modifications, and so now you'll see in the bill that there's $2.93 million for Special Olympics. And we also made a commitment that we'll continue to work on that issue, even in conference committee, and even next year, because the Special Olympics ask, that ask is not needed until 2026. So we wanted to really make sure that we are paying special attention to that. Members, those are some of the great highlights of this bill. I'll stand for questions, and I hope I can get your support with passage of our omnibus bill. Thank you so very much.
Further discussion of Senate File 5289. Senator Rarick.
Thank you, Madam President. I would like to offer the A13 amendment.
Secretary will report the amendment.
Senator Rarick moves to amend Senate File number 5289 as follows. Page 2, delete subdivision 2. This is the A13 amendment.
Senator Rarick.
Thank you, Madam President. Members, the A13 amendment looks to address an issue that has just come out recently because of a report and a new ruling by the EPA on PFAS levels in drinking water. And so, Madam President, what the amendment would do is it would reappropriate $3.922 million from the bill to the Public Facilities Authority in order to give grants to a number of communities in Minnesota whose drinking water does not meet these new EPA standards for PFAS levels in their drinking water. So, Madam President, it is not that we believe the other provisions were not worthy, but I think one of our roles here in the legislature is to prioritize the use of taxpayer dollars, and because of the recentness of this report and these new levels established by the EPA. I unfortunately did not have a bill that I had been able to bring forward, but that is why I have the amendment here, because I believe it is one of our top priorities, or should be one of our top priorities, to help our communities have safe drinking water. And so these grants through the Public Facilities Authorities would do just that for these communities, to be able to address those needs, to create the filtration systems that they will need to do to provide safe drinking water to those communities. Thank you, Madam President.
Senator Champion for a response.
Thank you so much, Madam President. And thank you so much, Senator Rarick. You and I had a chance to talk about the report that just came out. You did highlight the fact that there is no bill that's related to this important work. The other thing that I'd like to mention is that you realize, and others as well, is that even though there is something that DEED potentially could do, is not in our jurisdiction and has never traditionally been in our jurisdiction. So I would ask that you withdraw it, or the body to vote no, and based on that, I would ask for a roll call vote, Madam President. One, we do believe this issue of PFAS is important, and we believe that it should be considered and talked about. We just believe that this is not the right place in order to have that discussion. What I would like to also remind the body that in our policy bill, we did some work to support local governments who are dealing with this issue. So that's something that we have continued to deal with, something that we are highlighting, but we ask that this amendment not be something that is a part of our bill. And I will always make the commitment to have a conversation with DEED in order to highlight this, because the issue of PFAS is important. But I'd ask the body to vote no on this A13 amendment. Thank you.
There'll be a roll call. Senator Pratt.
Thank you, Madam President. I'd like to invoke a call of the Senate.
The Senate is under call.
Madam President.
Senator Pratt, we're in the middle of a roll call. Senator Pratt, if you would like to excuse
Thank you,
members.
Madam President. I wanted to clarify that the roll call was intended to be for the entirety of the bill.
Thank you, Senator Pratt. The roll call is for the entirety of the bill. The call of the Senate, I'm sorry, is for the entirety of the rest of the bill.
And Madam
And
President.
now, Senator Pratt.
Thank you, Madam President. I move further proceedings of the under the roll call be dispensed with, and the Sergeant at Arms be instructed to bring in the absent members.
And on that motion, all those in favor, please say aye. Opposed, say no. The motion prevails. Discussion. Senator Rasmussen.
Thank you, Madam President, and I thank Senator Rarick for bringing the A13 amendment. I would encourage members to vote in favor of this amendment because we are asked as a Senate to pick priorities. And to me, making sure that Minnesotans in the community that I represent have clean drinking water is really important. One of the communities that would be eligible for grants if the A13 is adopted is the city of Battle Lake. City of Battle Lake is in Otter Tail County. It has fewer than 1,000 residents, and they have found themselves on the PFAS list, where their levels are above the standards set by the EPA. And if we adopt the A13 today, that would give nearly $4 million in grant dollars that could go to communities like Battle Lake to help look at what they can do to address this concern in the community. And where we are taking this money from, Madam President and members, are from things that, in my view, should be less of a priority than clean drinking water. We're taking it from the Taste of Minnesota, from Explore Minnesota Film. Those are nice to haves. Clean drinking water is a must-have for Minnesotans in our communities, and I would encourage members to support the A13. Thank you, Madam President.
Senator Draheim.
Thank you, Madam President. And thank you, Senator Rarick, for bringing the A13 forward. Members, last year I made a pretty big stink to Senator Pappas about the bonding bill and the lack of funding for clean drinking water. And I still have communities that do not have clean drinking water. None of them are mentioned in this bill, but that shouldn't matter because that should be our top priority. And members, in committee this year, we had one of the governor's proposals was for $12 million for a sprinkler system for an 18-hole golf course. And to me, members, that is not as high a priority as clean drinking water. So I appreciate the creativity on the A13 that Senator Rarick is bringing forward and the urgency I think he stated in his opening remarks. So I support the amendment and urge everybody to support it.
Further discussion, Senator Champion.
Thank you, Madam President. Members, I rise just to make sure that I reiterate something that is very important. One is that the A13 is not something that is usually in the jobs bill. That is an environmental issue. It should be dealt with in real time. Senator Rarick is reacting to a report that he's had the benefit of reading. It was not dealt with in our committee at all. We do think drinking water is important. There's the right place by which to have this discussion. It is a priority for us. In fact, there was lots of work around PFAS last year and this year. It's going to continue to be so. That's why we also need a responsible bonding bill, because that's where this work can be done in real time. And again, I will ask for you to vote red, and we will continue to have the discussion, and it should continue to happen as a discussion in the appropriate committee that has the jurisdiction. So thank you so very much, and I ask that you vote red.
Further discussion before I recognize Senator Rarick. Senator Rarick.
Thank you, Madam President. And members, according to the committee, Jobs Committee on page 20, the Public Facilities Authority is under the Jobs Committee's jurisdiction. So I do believe this amendment is appropriate to be included within the Jobs Omnibus Finance Bill. And as we've stated, nothing against the other provisions that we're proposing to take the funding from, but drinking water is incredibly important for citizens in Minnesota. And Madam President, I did not just bring forward an amendment to deal with the two cities that happen to fall on the EPA's list that are within my jurisdiction. I included the municipal systems from Alexandria, Battle Lake, Brooklyn Park, Cloquet, Hastings, Lake Elmo, Newport, Pease, Pine City, Princeton, Sauk Rapids, South St. Paul, Stillwater, Swanville, Wabasha, Waite Park, and Woodbury, not to mention the Veterans Home in Hastings and a couple of manufactured home parks, one in Mower County, one in Washington County, one in Scott, and one in Beltrami. These are all groups, especially the cities, that the EPA mandates that they meet these levels. And this could be an expense that is passed on to their citizens and to the business communities of those areas that will make it next to impossible for future expansions to happen within any of those jurisdictions when people would look at the cost that is being put upon the citizens and the businesses in those areas. I do believe this is an appropriate place to put some money towards these grants to help these places that are on this EPA list to be able to meet the standards and for the folks who live there to have clean drinking water. Members, please vote yes.
Senator Rarick. Senator Pappas had raised her hand previously. Senator Pappas.
Thank you, Madam President. I just wanted to speak to this issue because
this amendment and this issue more properly belongs in the capital investment arena, in the Capital Investment Committee and the Capital Investment Bill. And we are very much aware of this problem. We've toured the entire state, and my members know that this is a very serious problem. Emerging contaminants, PFAS, forever chemicals, along with clean water, manganese, nitrates. There's just a tremendous amount of problems throughout the state, specifically in southeastern and southwestern Minnesota. And we will do our best to help these small communities and these suburban communities. I know Hastings was left out of the lawsuit. What's really important, though, is that for the members and for the leadership in both parties to provide us with those resources. We need a robust bonding bill in order to meet the needs of the community. And quite frankly, because of our limits, under Guideline 3, $980 million is the largest we can have with the bonding bill, and we have asset preservation needs as well over the state. But that doesn't mean that we shouldn't pay attention to this issue, and through the Public Facilities Authority, through the Department of Health, through the Minnesota Pollution Control Agency, all working together on programs that will help these local communities. So I would just respectfully ask the author of this amendment to really work with us and the Capital Investment Committee to make sure that we provide the necessary funding.
Senator Rarick.
Thank you, Madam President, and I appreciate those remarks. But as many of us know around here, you try to find as many avenues as possible to take care of something. You don't just pick one. And since the Public Facilities Authority is under the jurisdiction of the Jobs Committee, I believe this is an appropriate request. And as was stated, there are limitations onto the amount that our capital investment bill can be. And so I am looking to try to make sure that that limit does not impact these communities and this level of PFAS that we need to address. And so, again, I believe this is an appropriate way, and we will also be working on something to bring to Senator Pappas as well. This is just, again, kind of come onto our radar very recently, but so I'm going to be taking as many avenues as possible to try and help these communities out. So I would, again, request a yes vote, Madam President.
Secretary will take the roll on the A13 amendment. Senator Morrison.
Thank you, Madam President. Senator Dietzig votes no.
Senator Dietzig votes no.
And Senator Port votes no.
Senator Port votes no. Senator Jasinski.
Thank you, Madam President. Senator Anderson votes aye.
Senator Anderson votes aye. All senators having voted, the secretary will close the roll. There being 34 ayes and 33 nays, the motion prevails and the amendment is adopted. Further discussion on Senate File 5289. Senator Farnsworth.
Thank you, Madam President. And Madam President, I did have an amendment that I was going to offer today, but I spoke with Senator Champion off the floor earlier today, and he asked me not to bring the amendment, but just to talk about the amendment on the floor. And he assured me, he gave me his word, that he would work to include this in conference committee. And what the amendment would have done, Madam Chair, is that it would have taken $100,000 from this bill to pay for the Northern Lights Music Festival. And one of the reasons that I really wanted to bring this week is because in a couple of days we're going to be hearing a bill to name a highway after Senator David Tomassoni. And of course, transportation was one of his passions, but the Northern Lights Community Festival, or Music Festival, was also one of his passions. As you know, living in the North Woods where I live, we don't have a lot of access to some of those cultural things like classical music and opera. And so earlier in his career, Senator Tomassoni was able to fund this music festival to bring this type of culture to northern Minnesota. And it provides, for the 3 to 4 weeks of summer that they do this, it provides hundreds of jobs for local artists and food preparation businesses. And as Senator Tomassoni would have said, this is a good bill, and so I look forward to working with Senator Champion to get this into the final bill. Thank you, Madam President.
Further discussion of Senate File 5289.
Madam President.
Senator Champion.
Madam President, thank you. That is correct. I did have a conversation with Senator Farnsworth. What I did indicate to him that I would do everything that we could in order to try to get this provision included as a part of conference committee. And I am a person of my word that I'll sincerely try, but I also reiterated to him that I could guarantee nothing because we're dealing with the other body, and I just wanted to be clear on that. And I told him that I would give him, that I would make this statement on the floor as well. So thank you, Senator Farnsworth.
Senator Drazkowski.
Thank you, Madam President. I'm wondering if Senator Champion would yield for question.
Senator Champion, will you yield? He yields. Senator Drazkowski.
Thank you, Madam President. Senator Champion, on line 63.28 of the bill, you strike out the words "in the biennium ending on June 30th, 2027. So it appears in the bill that was passed last year that there was limiting language to limit these three accounts, to give the government the ability, both MMB and DEED, the ability to transfer money between these three different accounts, apparently for the purpose to take this slush fund and give it to the different organizations that it's given to. Why are we in the bill today striking the limiting language that says until June 30th of 2027?
Thank you. Thank you, Madam President. Thank you, Senator Drazkowski. To the line that you are referring to, currently agencies are able to, and especially DEED is able to transfer money around in order to make sure that they are meeting the needs of the businesses as well as the Forward Fund and others. So that is what's happening here, because from the testimony that we received from DEED, that this would be the best use and the best way by which to make sure all the aims and aspirations of the committee as well as the mission of DEED is being accomplished. So thank you, Senator Drazkowski.
Senator Drazkowski.
Thank you, Madam President. Thank you, Senator Champion. Senator Champion, members, that's what I suspected. I've seen it in committee lots this year and last year. Madam President, we have here again the executive branch dictating language in the bill saying it would like more authority to continue to do this beyond the limited authority the legislature gave them originally last year. They like that amount of authority and they want to have more of it. They want to be able to do it well into the future, and an unlimited amount is what it appears like in the bill with the new language in here. Members, this is once again another example of us as a legislature just simply handing over authority, carte blanche, to the executive branch. And again, at their request, and I've seen this, Madam President, again and again in committee, we've seen it in the bills, we are granting an enormous amount of authority to the executive branch. I am concerned about what this does, Madam President. What this does, again, is it makes the executive branch stronger and the legislative branch weaker. And in the meantime, we are giving away that authority. Just in this one example in the bill, and Madam President, Senator Champion, I'm not going to bring an amendment. I know what the outcome of that's going to be, but I just appeal to every member in here, as you are in discussions with the executive branch, don't give them language like this. Just don't do it. Thank you, Madam President.
Further discussion of Senate File 5289. Seeing none, the Secretary will give the bill its third reading.
Senate File Number 5289, a bill for an act relating to economic development, making supplemental budget adjustments for the Department of Employment and Economic Development and Explore Minnesota.
Third reading. Final discussion on Senate File 5289, Senator Draheim.
Thank you, Madam President. And thank you, Senator Champion, for bringing the bill forward. I just wanted to speak to the Special Olympics portion of the bill. And they had asked for $4 million, and I am asking you through negotiations as this bill moves through the process, if there is a way to get them more funding, that you would consider it. The economic impact for past Special Olympics members is $70 million. $70 million. I think that provision in this bill will have the most economic impact of any language in the whole bill. It'll bring people in from all over the world to Minnesota. So I just urge Senator Champion, as this moves forward, if we could find a few more dollars for that, I would appreciate it. Thank you.
Senator Dibble.
Thank you, Madam President and members. I would encourage a green vote on Senate File 5289, Senator Champion's Jobs Bill. I just wanted to thank Senator Champion for his special focus and consideration and attention to expansion of the Promise Fund eligible geographic area to include a number of businesses in the district that I represent who had received the kind of pressure and dire circumstances stemming from the pandemic and the uprising and some other phenomenon, and we recognize that at this moment in time that warranted some particular support, some help to these struggling mom and pop entrepreneurs who do so much to employ the people of our communities, to add to our economy, to innovate, and put so much of themselves. And unfortunately, in the area that I represent, we've lost 3-4 dozen of them already, but a number of them are hanging on, and I think this support will go a long ways. They're under a lot of additional pressure now from some substantial, I mean, I'm happy about it because we've got some significant transportation construction going on in the area, but it's all intersecting in the same spot at the same time, putting just that much more pressure on these small businesses that people are working really, really hard to make successful. Additionally, the geographic eligible area for the Promise Funds is expanding out into suburban areas. Likewise, a much needed relief and help for a lot of small businesses, which we know, of course, employ the most number of people. We talk a lot about our Fortune 500 companies, but the businesses that employ the most number of people are these small, innovative businesses that we have surrounding us in our communities everywhere. So thank you to Senator Champion for consideration, this excellent bill, especially that piece. Thank you, Madam President.
Senator Pratt.
Thank you, Madam President. I just want to take a moment to thank Senator Champion for a couple of provisions in this bill. We had a good, robust discussion in the Jobs Committee, but two that I'm particularly interested in. One, Senator Dibble just touched on. That was the expansion of the Promise grants. so often what we do is we create something that works for Hennepin, Ramsey County, and greater Minnesota, but we forget about the 5 suburban ring counties. And I want to thank Senator Champion for working with me to ensure that this truly is a statewide program and doesn't leave any of our communities out of it. And I particularly want to thank him for the inclusion of the Shakopee Workforce Development Pilot. Members, Shakopee, at least in Scott County, is a hub of our economic activity. And yet, Scott County is the only metro county without any presence of higher education. We have no post-secondary education that's permanently located in Scott County other than the Extension Office. And so, members, for residents of Scott County that find it hard to get to Dakota County VOTEC or to some other min-state facility, it becomes a burden. And as we've changed, as our economy changes, as our labor shortage continues, we're finding that more and more of our small businesses are having to pick up training costs. They're having to hire people that don't have the necessary qualifications that they would ideally like, and they're having to put that training in themselves, while they also are required to contribute to the Workforce Development Fund. And so, members, this is a way for us to help support and look at a new model that I hope can be expanded statewide, where all of our counties, all of our communities will be able to take advantage in a public-private partnership to now do workforce development, help our small businesses get the workforce they need. So thank you, Senator Champion, for including that, and I look forward to our continued partnership on it.
Senator Herb.
Thank you, Madam President. This might sound a little redundant, but I raised my hand earlier, right after Senator Hope, right in response to Senator Draheim, and but then it's okay that you're giving me the moment, and I want to just echo the Special Olympic. I'm the chief author of this provision, and so I really appreciate Senator Champion, promise Senator Draheim, and both Senator Draheim and I will be, in partnership and holding Senator Champion to his word. And I know for sure, 110% that Senator Champion is a person of his words, and we'll look forward to more funding for it. And Special Olympic has inspired many of us in many ways. Not just that, is the event itself is going to be an economic driver for our state, and also, the event also lead on to being a humanitarian event and create ambassador toward humanity for many of us. And I just want to share that component. I will be joining with Senator Draheim and working with Senator Champion to hopefully increase this dollar as we move forward. And also, I know that Senator Champion will look at other projects as well in terms of diversity to see if we can enhance that in many provisions in this bill. So thank you, Senator Champion. You're a good chair to follow and a great leader in terms of economic development. Thank you.
Senator Jasinski.
Thank you, Madam President. I also want to say thanks to Senator Champion for including the $350,000 to develop water and wastewater operator training at Riverland Community College. This will definitely help with the shortages of skilled workers in this field. So again, thank you, Senator Champion, for including that provision in the bill.
Senator Housechild.
Thank you, Madam President. Members, we've talked a lot about the EMS challenges that our communities face, and my region happens to be one of the areas where it is very acute. So during my travels and talking to community members about this issue, we developed the EMS emergency aid bill that is before us right now this session. However, I do want to tell a very brief story and want to say thank you to Senator Champion for including a provision in this bill that would help the Lake Superior School District create a pilot program for training high school students in EMT. This is something that was brought to me by one of my local commissioners in Lake County. They have a great nonprofit that runs their EMS services there. They're going to partner with the local schools and do EMT training, try to increase the workforce opportunities with EMS, which we know is one of the biggest challenges we face in Greater Minnesota when it comes to our EMS services. So a great pilot program. Thank you to Senator Champion for including it. Hopefully, if it's successful, it's something that we could extrapolate across the state and especially in Greater Minnesota, get our schools and get our young people involved in EMT and first responder training. Thank you so much.
Further discussion before Senator Putnam.
Thank you, Madam President. I just want to take an opportunity to thank Senator Champion for this bill, for the work that we did on it over the course of the session, but specifically to point out his efforts to help with the child care crisis across Greater Minnesota. Senator Champion has included some resources in here to help the folks who do child care do their job the best they can. And so I wanted to thank Senator Champion for that provision and make sure that all of you are aware that this bill stands up for child care in Greater Minnesota.
Any other discussion? Any other person wish to speak before I recognize Senator Champion? Seeing none, Senator Champion.
Thank you, Madam President. What I will say is thank you to the committee. Thank you for all the work that you are doing. And the committee I'm just so very proud of, that would be Vice Chair Senator Mohammed, Ranking Member Senator Draheim, Senator Gustafson, Senator Herr, Senator Housley, Senator Nelson, Senator Pratt, and Senator Putnam. I also want to thank my Executive Assistant, Shamika Bogan, our Committee Administrator, Tom Melton, our Committee Legislative Assistant, Alexis Varner, Senate Counsel, Carlin Dorr-Fontaine, as well as Senate Fiscal Analyst Hannah Grunwald-Noder. Danny Gillis, our caucus researcher, we're proud of him also because he just recently had an addition to his family, so he was helping us all while his wife was doing all the hard work, I will say. But we are so proud of him and so thoughtful. And we want to thank Jack Vicks, who had been filling in for us while Danny was out, Andy Larson, the GOP researcher for our committee, and Ben Petty, Senator Mohammed's LA, who helps us run Zoom in our committees. I wanted to also make sure I mention our interns, Ava Roots, as well as Corey Stockard. They are studying hard because they're getting ready to, at least one I think is getting ready to graduate. And our pages, Kylan Johnson and Will Olson. Members, we did the very best that we could with this bill. We think it represents our values, and we hope that we can get support from you. And I would hope that it wouldn't just be a bipartisan vote, because then I think that would be unfortunate and telling. So thank you so very much, and I look forward to you voting green.
The Secretary will take the roll on Senate File 5289. For Senator Morrison, for those voting under Rule 40.7.
Thank you, Madam President. Senator Dietzig votes aye.
Senator Dietzig votes aye.
Senator Port votes aye.
Senator Port votes aye. Senator Jasinski.
Thank you, Madam President. Senator Anderson votes no.
Senator Anderson votes no. The Secretary will close the roll, all members having voted. There being 34 ayes and 33 nays, the bill is passed and its title agreed to.
Madam President.
Senator Murphy. Senator Murphy. Senator Johnson.
Thank you, Madam President. I rise for a point of personal privilege.
Senator Johnson, state your point of personal privilege.
Pursuant to Article 4, Section 11 of the Constitution of the State of Minnesota and Section 696 of Mason's Manual of Legislative Procedure, I am presenting to the President a protest and dissent letter which is to be recorded in today's Senate Journal.
Senator Johnson.
Madam President, if I may. We, the undersigned, submit this letter of protest and dissent in response to the vote on Senate File 5289. Passage of Senate File 5289 relied on the vote of a senator who has been charged with a felony count of burglary in the first degree. Senator Mitchell's actions have put the work of the Minnesota Senate under a cloud of public distrust. According to a criminal complaint describing her arrest, the facts of which are attested to under penalty of perjury to law enforcement, Senator Mitchell entered her stepmother's home through the basement window in the early morning hours of April 22nd, dressed in black, carrying a flashlight covered with a black sock to mute the brightness of the light, and attempted to steal items that did not belong to her. According to the 911 call, the transcript of the incident, she was allegedly lying on the floor next to her stepmother's bed and startled that individual when she got out of bed. And I quote, this is the stepmother, no, it was completely dark. I tripped over him. He was on the floor next to my bed. He ran downstairs into the basement. After being apprehended by police on scene, Senator Mitchell told officers, I know I did something bad, and I am not good at this. These statements of guilt clearly allow a reasonable person to question Senator Mitchell's judgment here on the floor. Since her arrest, Senator Mitchell has made public statements which contradict those she made to law enforcement. This type of action is contrary to the expectations of Minnesotans. Since her arrest, residents in her district have begun recall efforts. Since the arrest, Senator Mitchell's stepmother has been granted an order of protection due to her stated fears of Senator Mitchell by the judge presiding over the case. We protest and dissent against the vote on Senate File 5289, which was adopted by the Senate, with a deciding vote being cast by someone who is clearly unfit for office. We believe it is an abuse of the power of both Senator Mitchell, the Senate Majority Caucus, and its members, signed by the 33 members of the Republican caucus.
Senator Murphy.
Thank you, Madam President. I move a brief recess for the purpose of appointing conference committees.
To that motion, all in favor say aye. Aye. Opposed say no. The motion prevails. The Senate is in recess to the call of the President. The Senate will come to order. Senator Murphy.
Thank you, Madam President. Is there a privileged report at the desk?
Yes, there is. The Secretary will read the report.
Senator Murphy from the Subcommittee on Conference Committees recommends that the following senators be, and they hereby are, appointed as a conference committee on Senate File Number 3492. Senators Mohammed, Umover-Bayton, and Housley. And Senate File Number 4579, Senators Dibble, Port, and Weber. Senator Murphy moves that the foregoing appointments be approved.
To that motion, all in favor say aye. All opposed say no. The motion prevails. Senator Murphy.
Thank you, Madam President. Members, I'm going to call a recess till the call of the President. We will return with a skeleton crew after the completion of the work of the Rules Committee. And with that, Madam President, I move a recess to the call of the President.
On that motion, all in favor say aye. Opposed say no. The Senate is in recess.